I'm going to introduce myself by way of my professional background in a minute, but my name is Jennifer Rennie, and I am indeed from Pittsburgh. So I travel all around the country, and I do a lot of research and writing and training of judges and lawyers on all things child welfare. But it is wonderful to be back in Seven Springs, where I spent many a youth group trip up here in junior high. I said to Terry, she said, well, I thought this is your neck of the woods. I said, let me put it this way. I'm 46 years old, and last time I was in Seven Springs, I don't think I had a driver's license. But it is great to be back. I am originally from here, and let me tell you a little bit more about who I am and how I came to co-author this book. So, as I'm giving the introduction on my professional background, you'll get a sense of why I thought there was a need, a pressing need for this book. And by the way, Justice Baer said it himself. I do about 10 minutes on the need for this book, but when he said that he knows very little or didn't have any kind of formal education on safety decision making, it resonated with me because we hear judges and lawyers all around the country say that same thing, that they went to law school, not social work school, and that they really don't have training on the fundamentals, the basics, and that leads to problems, which I'll get to in a minute. So I have been in child welfare about 20 years, and I started my career representing children in abuse neglect cases in what is now my home state of Maryland. I live right outside Washington, D.C., so I practiced in a very urban environment. The two counties, the least affluent counties contiguous to the District of Columbia, so it was a very high volume kind of practice. I was there 8 years. I supervised the child advocacy division for my last 3 years there. And then in 2000, I went to the American Bar Association, where I worked for, it's a long title, but it's the National Child Welfare Resource Center on Legal and Judicial Issues. I'm now the director. I've been the director of the Resource Center on Legal and Judicial Issues for about 5 years. I'm also an adjunct professor at Georgetown Law School, where I teach ethics, so not child welfare, but ethics to students that are interested in pursuing public interest careers. So when I was in practice representing kids, you know how it is when you're fresh out of law school and you've got all that energy and enthusiasm. I took a job at the Legal Aid Bureau, followed my heart, and took my law degree out to change the world. I was amazed at, you get this training volume, this big thick manual, and at Legal Aid you're in court after about a week or two with some supervision. But I said at one point, well, where is the training on what is the standard for removing a child or reunifying a child, which to me, I knew 2 weeks into the job, were the most important decisions that were being made. And there were really no good answers, and I kept exploring that question. After I was in practice about a year and had become friendly with a number of the attorneys and the judges in front of whom I practiced, I asked one of the judges, and he was, I don't know, maybe 5 years away from retirement, so he had been on the bench a long time, and I said, well, how do you make a decision? What kinds of information do you consider, and what are the standards, and what is the criteria and the methodology under which you make a decision whether or not to remove or reunify a child? And he paused and he said, I think it comes down to gut instinct. He said, I've been doing this a long time. And this was a judge that had pretty good gut instinct. But I thought, we've got to do better than that. We've got to, in the legal field, have more than a cursory understanding of what goes into safety decision making. So I knew very early on in my career, and I'm going back to the early 90s now, that there was a need for this book. So I was at that time in no position to write it. When I came to the Resource Center, and I should also say by way of background that my Resource Center, and it's Therese Rowland, but she goes by Terry, so Terry's Resource Center, and she works for the Resource Center on Child Protective Services, and she'll say some words by way of introduction about herself when she takes the microphone from me, rips it out of my mouth in a few minutes here. But our two respective resource centers collaborated on this effort because I knew that this book needed to be written, but I knew I couldn't write it alone. Why? Because it's grounded in the basics, what's commonly understood in terms of social work principles and ideas and concepts. So together we came together to write this as a partnership, and we'll talk more as the presentation unfolds about sort of the discovery process of that partnership and what we think is key and crucial for the legal community to understand about safety decision making. Our two resource centers are part of a broader resource center network. So we're funded through the federal government. The Children's Bureau, which is an arm of HHS, funds us. And our fellow resource centers cover a wide array of topics such as youth development, permanency and family connections, organizational improvement, data and technology, adoptions. So we all work together primarily with child welfare agencies, but also obviously with judges and lawyers. So that was a little bit longer by way of background. Let me see if there's anything here. I talked about the background and purpose of the guide. Obviously, safety planning is a shared responsibility, and the courts are making the ultimate decisions. Without sufficient training and understanding of what goes into safety decision making, you fall into a couple of different pitfalls. One is that the judge, who doesn't want to second guess what the child welfare agency is recommending, you maybe heard the term rubber stamps. Will rubber stamp the agency recommendation? And I was talking to not the same judge, but another judge, and I said, well, about this issue, the problem of rubber stamping the agency recommendation, he said, I have concerns about it all the time. He said, the agency comes to court with a paltry amount of information asking me to remove a child. He said, but I don't want to go against that recommendation. He said, because I don't want that blood on my hands. So I'm going to tell you, he says, I don't like these cases. He said, I prefer a criminal case. He said, where, you know, I can sit there and make rulings on evidentiary motions, that kind of thing. But when I have to make a decision about removing a child, I don't want to second guess the child welfare agency, and I don't have enough information to justify my decision anyway. So that's a problem. Now, the reverse can happen as well with insufficient information and judges making decisions based on information that comes to them either at a shelter care hearing or even at a permanency hearing into the case, can make decisions that aren't supported by the evidence, if you will. So with judges and lawyers lacking the sufficient training in the basic principles of safety assessment and planning leads to a number of different problems. The final bullet up there is the idea that once the judges understand and the lawyers are better prepared and the judges understand these basic principles and ideas, that practice will be elevated. In other words, if a caseworker comes to court and she knows that every time she comes to the court hearing, the judge is going to ask her a series of questions about the facts of the case and ask her a series of questions about her thinking and the decision making that went into the recommendation, then practice is going to be elevated. And I think you'll see that. It's a little conceptual at this point in the presentation on the slide, but you'll see that clearly as this unfolds. So the purpose of the guide is to provide the legal community with practical information about child safety. So, number one, judges and lawyers can assess whether the recommendations are based on sufficient information. I've used that term a couple of times, sufficient information. So we're going to start out with the premise, and this is not personal to you or to the counties in Pennsylvania. It's not personal to you too, because as I'm speaking, you'll probably, I already have seen some nods, what I'm saying will resonate with you. So a problem in child welfare across the country is that we make these kinds of decisions based on insufficient information. We're going to define what sufficient information looks like, or at least at a bare minimum, what the caseworker ought to have when she comes to court. But for now, the assertion is that these decisions are made on information that really does not tell you what is going on in that family. Therefore, how can you know whether or not that child is safe? The second bullet up there is that judges and lawyers, after working with these principles and ideas, will be able to assess whether the recommendations are based on a thorough analysis of specific criteria. So we're moving away from gut instinct. We're moving away from how we feel when we see that petition and we hear what the initial allegations are. There's a problem oftentimes where we get sucked into the initial maltreating incident, and we focus on that to the exclusion of a whole world of information that's relevant to whether or not, to answering the question whether or not this child is safe. So the third bullet there is that really, you could say very simply, the purpose of the guide is to make good decisions about child safety. And then what you see up there in red is the first point, is to keep kids out of care who don't need to be there. So we have kids in foster care who don't need to be there. What do I mean by that? They would be safe if they were home. The second point's related to the first point, which is perhaps there were kids that initially did need to be in out-of-home placement because they were unsafe, but they're languishing in foster care because we've taken our eye off the prize and we stopped looking at safety at our 3-month, our 6-month, our permanency hearings. So the second point is to get kids who initially needed to be in care returned home without unnecessary delay. Maybe you've heard that term, raising the bar phenomenon in child welfare, and what's meant by that is that you come to court at the 12-month permanency hearing, and mom has kind of sort of complied with the case plan, maybe not 100%, but some of these family service plans I'm not sure that I could comply with 100%. But we say, well, you know, the child's really bonded with the foster parent, seems to be doing really well there, and there's this unease or discomfort with returning home, but nobody puts it in terms of safety. No, there's no specific criteria. And we call it raising the bar because if the mother or the family from whom the child was removed was functioning at that level 12 months into the case, if they had been functioning at that level when the case initially came in, the child never would have been removed. But we say, well, it's not in the child's best interest to be returned home. But we never specifically describe what the safety considerations are and why that child would be unsafe if returned home. And then the third bullet there, as important as the first two, is that there are kids at home who are unsafe. So the third purpose of the guide is for kids who are unsafe at home to implement an in-home safety plan or have them removed and placed in care. So thinking errors result in children being removed who shouldn't be removed. Thinking errors result in children who initially needing to be removed languishing in foster care because we stop thinking about and we take our eye off the prize and we stop identifying the safety consideration. But it's equally important to remember that thinking errors also result in leaving kids at home in unsafe conditions, in unsafe homes. So that's the basic purpose of the guide. So the objective of this presentation, I don't want anybody to walk away under the misimpression that you're going to spend your afternoon here hearing from me and hearing from Terry. And by the way, I know it's a big room, but this is intended and designed to be provocative, to stimulate your thinking. So please feel free at any time to raise your hand to ask a question, and we will pause from time to time to see whether or not there are questions. So we don't want you again to be under the misimpression that after this afternoon, you're going to be able to go out in your community and make the changes that you think might be necessary in order to raise up your game in terms of the safety decision making. It will be informative, you will have insights, you know, you may even leave enthusiastic about what you might do, but it's not necessarily going to lead to any kind of implementation. What this is is an overview presentation of the basic ideas and principles in the safety guide. And we will familiarize you with these principles and ideas and show you some case examples in the guide. The second half, the right-hand side of the slide, says begin consideration of whether to use the guide in local core communities. So I know you're sitting at your tables with your team members from your county, which is great. So during breaks or structured time when you have an opportunity to talk with your team, talk about whether or not implementation of some of these ideas is something you want to consider. Implementation is hard. Tara's laughing. You know, it's like we do this a lot. What I mean by this is different presentations, but we don't often do presentations. We refer to them as ballroom events anymore because we're spending our resources doing implementation work. So we work with much smaller groups of people, and it's very specific work in terms of rolling up your sleeves and let's take a look at what you're doing and how can we assist you to move from what you're doing and implement these ideas. And it's difficult, and it's not that it's difficult because there's resistance to the ideas. It's difficult because implementation is hard and takes time. So we will talk about how to use the safety guide and how to access technical assistance to explore implementation if that's something you're interested in. So you will notice you have a copy of the guide. I will note that it's not the one that we sell. Pennsylvania has produced this, so it's a lot cheaper for you, and I think it's just fantastic. We have no proprietary interest in the guide. We sell them at cost. So every time I come and see, instead of 402, how many was it? 402 book sales, and I see that that the steering committee has reproduced the guide without one dime going to us. I'm just thrilled and delighted. Besides, then we don't have to sell out, and we're in like the fourth printing of the guide. Yeah. And anytime you try to get anything printed through the American Bar Association, well, it's a lot of bureaucracy. So you've got a copy of the guide that's been printed for you. So we're going to refer to it from time to time because I don't want you to spend the afternoon hearing all these ideas and not know where to find that in your guide. By the way, this went through several iterations, and the final version was about half the size, maybe not quite, but maybe about half the size of the original. And, you know, when you write something, you get really attached to what's in it, but when it went through the reviews, including child welfare administrators and judges who reviewed it, they said, well, the content's great, but it's too long, no one's going to read it. So, and I know this as a law school professor too, if I assign 100 pages, the likelihood of it getting read is not very high. If I assign 15 and I say, I expect you to come to class prepared having read these 15 pages, they usually do. So this is a lot shorter than the original version. So everything in here is in here for a purpose and we think is valuable and is designed to move the conversation forward. So you've got the text, you've got the bench cards, which we will refer to, and the bench cards are not intended to be something that the judge goes down by rote and asks these questions from the bench, although some of the bench cards can and are indeed used that way. But the bench cards are more to remind you of the essential principles and ideas, and then of course case examples. Couple ways to get the guide. They're on both of our respective websites, so the ABA website and the Terry's Resource Center's website, and then there's information there about how to purchase it. It's also on the OCFC website and is part of the Bench Book Resource Companion, so any number of ways to access it, and these are obviously the online version. So the online version is essentially what's been printed for you. Legal terms. When you're writing a book that's intended for a national audience, people said, well, how are you going to do that when most states have different statutory language with regard to risk and safety? And they do. And I keep saying I'm going to do this and haven't done it yet, but I'm going to do a search someday of all 52, that being 50 states and the District of Columbia and Puerto Rico, and cross-reference the state statutes, but I feel fairly confident saying from the front of the room, without having done my homework on this, that no two states have identical language in their state statute with regard to risk and safety. However, they all have similar language: imminent risk, risk of harm, threat of imminent harm, etc. Here's what you need to know about the statutory language. We distinguish between safety and risk. When I was in practice, and even in my first years at the Resource Center, I confused these two terms and I used them interchangeably. They're very distinct, separate principles. When we say safety, we're going to define it a couple of different ways, but when we say safety, we're concerned about imminence. So there's a temporality aspect to it, and severe consequences due to things being out of control. That's our definition of safety, and we're going to pick it apart and show it a few different ways. Risk, on the other hand, is a vague concept regarding whether something might occur if there is not intervention. Risk may be mild, or risk may be serious. Regardless of the terminology in your statute, the critical question that we're addressing is whether or not the child that's in front of the court at this hearing is safe. So another way to say that is that all children are at risk. Look again at the definition of risk and see if you can see that for yourself. They're all at risk. Safety is a very different thing, and we're going to define safety in a very rigorous way and apply specific criteria to the definition of safety. Can you also see that regardless of the terminology in the statutes of all 50 states and 2 jurisdictions, all 52 jurisdictions, that we're all doing the same thing when we remove a child? I'm a lawyer's lawyer. I love being a lawyer, so it's a little bit strange to stand up here and say, I really don't care what the state statute says. When you're removing a child, you better be clear about the criteria for safety. You better be clear about what you mean when you say this child is not safe. And I can tell you why this child is not safe, and I can present evidence to support the declaration that this child is not safe. I'm about to turn the microphone over. Let me see whether or not there are any questions. Okay, terrific. Terry?
Good afternoon. Are you awake? Can you hear me? Okay, maybe I need to get a little closer. I'm Terry Rowland, as everybody has already said, and I'm the Associate Director of the National Resource Center for Child Protective Services. As Jen already described with respect to our 2 resource centers, we're part of a network of a dozen or so funded by the feds so that we provide free technical assistance around our areas of expertise. So in general, our resource center, we have about 12, 14 staff all across the country. We travel, and our general customer is the local or the state child welfare office. And we work with them around any aspect related to child protective services, whereas Jen's, of course, would be working with the legal folks, the partners in the child welfare system. There's resource centers on permanency, data and technology, all sorts of other areas of topical expertise. This venture related to writing and then publishing this guide is a little bit off the charts in terms of how the resource centers generally work. While we like to be collaborative, because that is a very important word these days for all of us. This venture, I would say, started with just some conversations about the fact that Jen and I would often be at different events like this, maybe doing separate workshops, separated by some partition, often with a mixed audience of different professionals coming together and being asked the same questions on either side of that accordion wall. And so we started talking about the fact that maybe it makes sense for us to be giving the same answers, or at least using the same framework in order to arrive at what we think are the right answers, or the right way to go about a logical and sequential way to make decisions in child safety. So that's a little bit about how we have, since the beginning of the writing of this guide, which Jen alluded to, several iterations, many, many edits. That was probably a 3-year process. Jen had at least one child during that time. My child graduated from high school. We had all sorts of milestones that we went through, and still no published guide at that point. But once this publication came together, what we have been really spending an awful lot of time on, whether I'm jointly participating with Jen in these TA events or with her colleague Timothy Travis, occasionally some other folks from my resource center join in and do this. We tend to go together. The whole process, as Jen walked you through, of what this is really about is to get the professionals from opposite ends of the continuum a little bit closer to the middle, so that we're talking about these essential decisions not from a book of statutes, but neither from a social work text, but putting this in the realm of critical thinking, of logic, of sequence of steps that make sense and can be rigorously justified. You folks in the room who are my child welfare brothers and sisters are likely not going to hear anything new. We're not trying to teach you about child safety decision making. At this point in time, there isn't a state in the nation, or Puerto Rico or DC for that matter, who don't have a practice model that employs the same principles that we're going to be talking about today. So what we're trying to do is to not teach you a brand new thing. You won't see anything in this guide that look like forms or templates. It won't obviously be in Pennsylvania's current or local language for how you reach certain kinds of decisions and what you call a treatment plan or a family service plan. It's a national publication. But we're confident, not just based on doing TA related to this guide, but really in the span of years that both Jen's Resource Center has been providing technical assistance, in the 15 years that we've been traveling around the country and working with child welfare in all the states, is we know that the principles that are in this guide are consistent with the practice model that's used here in Pennsylvania. What we're asking you to do is to humor us as we talk today in the language that's in the guide rather than in your local Pennsylvania speak, but to be cautious and to be thinking about whether the way we use certain concepts is consistent with or inconsistent with the way you use those same concepts, even if you call it something else. And if it's inconsistent, is that an okay thing? Is that a bad thing? Is that a good thing? That's for you to decide as we walk you through. I haven't said anything about myself. There's a bio in the book. I'm anxious to get into the heart of this, but I just got to say, since I'm here outside of Pittsburgh, is that I was born and raised in Green Bay, Wisconsin, and I'm a stockholder and a ticket holder. I live in Madison, Wisconsin. You see, I don't even have to tell you what I have tickets to, right? I live in Madison, Wisconsin, so I make that trek up to Green Bay 2.5 hours, about 6 Sundays a season, because we share tickets with our brothers and sisters in Milwaukee. Isn't that cute? Because, you know, we're we're a home-based team. So anyway, but it's nice to be here. Jen and I struck a truce a long time ago and actually texted each other during that infamous Super Bowl. And so it's nice to be here. Although I have to say, I'm going to need to leave today at 4 o'clock in order to get back to the airport. I am taking a flight to Milwaukee. It's just happenstance that it's in my backyard where I'm doing TA starting tomorrow. And the only reason why I'm telling you this is because it sort of links into what the purpose of this day is. About a year or so ago, we did, our 2 resource centers provided an overview, much like what Jen and I are going to go through today, to a group of about 35 key leaders in Milwaukee County related to the guide and what it might take. And we spent actually a day and a half together. So you're getting the accelerated, the smart classroom presentation. We took our time and spent an entire day going through this guide with a group of key leaders, and by leaders I mean we had judicial folks, we had DA's office, we had the Bureau for Milwaukee Child Welfare, we had Guardians Ad Litem, private parents' attorneys, public defender's office, and CASA. Not everybody, but key leaders, because we have really gotten, I think, a lot smarter as we've been trying to help communities look at the guide, and when they're enthusiastic about wanting to try to pick a few of the ideas that are in this guide and implement them at their local level, we're better able these days than we were, say, 2-3 years ago, of knowing who needs to be in the room to make this decision, to own this decision, and to oversee this decision going forward. And that's the follow-up TA that we like to provide. So we started about a year ago in Milwaukee and have met with then a subset of that group of 35 leaders. And tomorrow I'm going back to begin a 2.5-day technical assistance site visit, because what we're taking apart is we're starting at what they call a temporary physical custody hearing, the initial emergency hearing, so whatever you call it here in Pennsylvania, and looking at the sufficiency of the information that is brought to that type of a hearing, the quality of the decisions that get made, what happens after that hearing is over. And so I'm going to Milwaukee to start at 8 a.m. tomorrow to be at the courthouse to observe the process of the DA's office conferring with the Bureau staff in preparation for those hearings, and then sitting in and watching those hearings happening, and then meeting with leadership by the end of the week to give some feedback about what they might want to change. So sorry for all that detail, but it is sort of an inkling of, after an event like this, what sometimes happens, and it definitely is a local decision of whether or not, certainly the ideas we're going to talk about need to be adapted for your language, your usage, but also we're not expecting that we're going to talk about ideas between these 2 covers of this book and that you're going to like all of them or feel like they're of equal weight or value or whatever. So Milwaukee made some decisions about where they wanted to begin, and we're providing that. So I'm going to be leaving at about 4, and you're in good hands with Jen, as you could already tell in the first 15 minutes of this presentation. So let me talk about the slide that's right up here on in the front of the room. Jen walked you through a couple of slides that are meant to have been bullet points of, like, what's the purpose of this book that we put together. And I think that even though those slides were fairly pithy, 3-4 bullet points, it really comes down to one major objective that we have to communicate to folks like you, is that this is all about making sure that when you go home to your respective communities, you feel confident that you have the right kids sleeping in the right beds. that the removal decision, I think we could have agreed altogether without calling together a summit. Removal is about keeping a kid safe. That's the purpose of the removal in a child protection matter. Certainly in other sorts of cases that you might all grapple with, older kids, kids with mental health problems, juvenile justice types of cases, we're not talking about the same kind of thing. But when we're talking about concerns about maltreatment, risk of maltreatment, and whether or not kids are safe, sometimes we have to reach a decision that the only way to keep a child safe is by having that child sleep in somebody else's bed, whether that's grandma's bed or whether that's in stranger foster care. But what we want to do, and we're going to push at this several times throughout this afternoon as we walk through the chapters of this guide together, is that, as Jen was talking about, we sometimes lose sight of what the reason was for the removal and start raising that bar so that reunification becomes an issue of treatment compliance or fixing everything so that people are now functioning way better than they ever needed to be functioning. And as she so well said, and I sometimes stumble about this trying to describe what I mean, but I bet you know what I mean without finishing the sentence, is that these families are often, we're holding them to standards that are higher than we would have at the front end of our system, our child welfare system. If they were functioning at that level earlier, we might not have ever removed the child. We might not even be serving the family. So what we're trying to do is to look at this thread of logic, of critical thinking, and walk it through each step so that we don't lose sight of what it would take to keep a child in the home with an in-home safety plan. So not necessarily talking about reunification as being the time that everything is fixed and we can throw a pizza party and back out of the case, but that we're looking at, there comes a time when I'm working with a family where I can justify to you that no in-home safety plan will do. It won't be sufficient to keep this child safe. It's only by having that child sleep at another address that I can keep that child safe. Well, we're going to look at whatever those criteria are to help me decide that it's only out of home. We're going to return to those criteria later on to say, can we meet those criteria now so that an in-home safety plan will work? So that return uses the same criteria as placement. What we really believe, and the reason why I mentioned to you that we try so hard to make sure that we are always on site together as many times as possible. Sometimes it just can't happen because of travel problems, and you know, I'm leaving today at 4 and Jen is here. But what we have found is that in the process of writing this book together, we had to spend a lot of time trying to understand each other's way of thinking. And by each other, I don't mean personally Jen and me, I mean the two professions, child welfare, social work, legal, of trying to figure out how to have a common way of talking about these decisions without referring to either statutes or a social work text. We have to find a way to talk about what is the relevant information that we're going to hold each other accountable to use and to use to justify the decisions that we're making, or that we're going to have passionate debates about and come to no consensus. But we're at least going to be arguing about the relevant kinds of information that needs to be yelled about and debated in order to arrive at whatever the decision is going to be. So this book takes this apart and tries to help us understand that there is a way for us to all have a common conceptual understanding, but it's not good enough to have it conceptual, but to apply those concepts of what do we really mean by when a child is unsafe or when a child is safe. Is it tied to the incident of maltreatment? Is it tied to a certain number of previous reports? What is it that makes up what we believe is an unsafe child, and what's the common body of information that we're all going to say is necessary in order to reach that decision. So we'll walk you through that. I've already mentioned to you, this is not about trying to introduce you to yet another practice model. This is about trying to dig through your own practice model that you use in your local child welfare agencies and try to understand what are those critical thinking principles that underscore this practice model. Help me understand, if I'm the legal person, what they are. I need to know what they are in order to advocate for the best decisions possible. This is an example. We're going to talk about these key concepts throughout the day and how they make up the definition of what constitutes either a safe child or an unsafe child. And it came out of quite a few meetings in the very beginning of putting the idea for this book together, is that I would travel to DC and meet with Jen and her colleagues at the ABA office, and we would munch on all of her good healthy snacks, and I would sneak out and get some chips, and then I would go through the endless articles that our resource center has written about child safety decision making and the PowerPoints that we've put together and all of that. And I can remember at one point Mark Harden, who some of you probably have met over the years, one of Jen's colleagues, sat through several of these iterations and said one day, so really there's three elements to this. There needs to be a threat, there needs to be a vulnerable child, and there needs to be an absence or the presence of protective capacities, and that's what gets you to the idea that there's a safe child or an unsafe child. And I can remember sitting there thinking, this is not how I would teach this to a room full of social workers, but you know what? This is exactly it. This is exactly what the elements are. And it's how we've taken the two professions and tried to pull this together in what we think is a much more pragmatic way to think about decision making, but also playing to the strengths of the legal community's discipline and their training and use of critical thinking principles, so that you'll see this over and over again as we go through these steps to decision making.
Great, thank you. So we like to put, we know we haven't defined these terms yet, but we like to put this up here so it's a little bit of a roadmap in terms of where we're going. So the idea is that we're saying that an unsafe child is a child where there are threats, a threat or threats of danger present in the home. Don't worry, we're going to define that. The child is vulnerable to those threats. And then the family lacks protective capacity to manage those threats. That's the essence of the definition of an unsafe child. And again, we're going to define each of those terms. Also, by way of a roadmap, I like this slide because for a couple of reasons. One is you can the background colors up there correspond with the colors of the slides, okay? So we're going to be talking about different things at different times. The background color of the slide, if it's that red color up top, that means it relates to the court process. If it's that blue color, it means it relates to information gathering. The green color relates to safety plans. We distinguish between safety plans and treatment plans, or the treatment plan would be the same as what you call it here, the family services plan. They're two very, very, very different things, different ideas, different concepts. Again, when I was in practice, I collapsed the two distinctions and it led to trouble. So that's the first reason I like the slide. The second reason I like the slide is it shows you the chronology of this. When we first were writing this guide, people said, well, why don't you organize it around the court hearing? So here's a checklist of questions to ask at the initial hearing or the shelter care hearing or the initial removal hearing. Here's a list of questions to ask at the review hearings, the permanency hearings, etc. And we rejected that because the questions that you're asking about whether or not the child is safe are the questions you ask at each and every court hearing. Now, where we are in the court process is important. And I'm going to talk about early on in the case what a reasonable expectation would be for information collection versus later on in the case. So I'm going to talk about that in a minute. So the court process is important, but you wouldn't want to organize something like this around the different court hearings because the questions are the same at each and every court hearing. I also like the slide because it presents as a visual the ongoing obligation to gather information. How many times have you gone to court and you might even have a pretty good court report with some pretty good information in it at the adjudication or the merits hearing, and then you see that same stuff, sometimes literally cut and pasted, and it shows up 6 months down the road or maybe even 12 months down the road, and we're cutting and pasting the same information over and over again, where the obligation, you will see when we start talking about the criteria how important it is to continue to gather relevant information about the functioning of the family, and that obligation endures throughout the life of the case. It may sound obvious, but when you look at court records like we do, from what we see in the court records, either people have dropped the ball on gathering sufficient relevant information for that point in time, or it's not being documented. And then if you look at the safety plan, the idea here is that we always need to be asking ourselves, will an in-home safety plan be sufficient, feasible, and sustainable in order for this child to either remain at home or if they're in out-of-home care to be returned home? It's a question that gets asked early on in the case, but then sometimes we drop the ball and we forget to ask that question again 6 months, 8 months, even in between the court hearings, to ask that question. Have the circumstances in the family changed, such as the threats have diminished and the protective capacities of the family have been enhanced, that an in-home safety plan will now suffice? And then the treatment plan, the reason it doesn't start early on in the case is that that family services plan really isn't developed until after the adjudication. And again, we're assessing the needs and the progress of the family. And has the threat been reduced, and have the protective capacities been enhanced? So we pose this question. We're going to do it as a rhetorical question given the size of the room and the amount of time that we have. But sometimes we actually ask this question, and it's interesting the responses that we get. So just sit with it and think about what your own answer to this question is. How do you know whether a severe injury of a child represents a pattern of dangerous family conditions or is a one-time incident? How do you know? And is it the information, if you're a lawyer in one of these cases or a judge in one of these cases, or even from the social services agency in one of these cases, privy to more information than what's getting filtered up to the judges and the lawyers? How do you know? How do you answer that question? And I submit to you that as you're sitting there contemplating that that's the essence of the need for some criteria and understanding the basic principles here of safety decision-making. Before we talk about what sufficient information looks like, it's important to understand that judges and lawyers need to be able to assess whether there's a sufficient showing of evidence. So we're going to talk in a minute about what sufficient information might look like. So think about that in terms of the evidence that you ought to expect to be presented in the case in order to make a decision. The answers to what we will refer to as the 6 questions is what we assert is the bare minimum that the court needs to know to make safety decisions. So I'm going to ask you to pull out bench card A in your handouts. If you can't find bench card A, they're stapled together. Either get someone at your table to show you where it is. If that doesn't work, raise your hand, because it's really important that everybody has bench card A in front of them as I'm talking about it. Raise your hand if you don't have it. Great. So this is what we're asserting is the minimum amount of information that we need to know. Remember when Terry popped that formula up there, that an unsafe child means threats are present, child's vulnerable to the threats, insufficient protective capacity to manage the threats. You cannot assess for threats or for protective capacities or for vulnerability without having this information. So question number 1, what is the nature and extent of the maltreatment? Type of maltreatment, severity, maltreatment history, etc. So that's important, right? I mean, we alluded to earlier that there's this focus, sometimes to the point of obsession, on the maltreating incident. So we're not saying it's not important, it's important. But it's only one of 6 questions. Question number 2, what circumstances accompany the maltreatment? So still related to that maltreating incident, but going a little broader. How long has it lasted? What's the parental intent concerning the maltreatment? Was the parent impaired by substance abuse, mental health, etc., or otherwise out of control? How does the parent explain the maltreatment and the family conditions? Do they acknowledge the maltreatment? What is their attitude? Other problems connected with the maltreatment. So you with me so far? So question number 1 and question number 2. Probably that's the kind of information that's being presented, at least early on in the case. Information that answers those questions. And it may not, I mean, you can look, those are just some very simple bullets. There's a whole chapter explaining this, but some very, very simple bullets on the bare minimum in terms of what question number 1 and question number 2 is talking about. Now, look at 3. How does the child function day to day? Capacity for attachment, general mood and temperament, communication, behavior, school performance, health, independence, skills. So moving beyond the maltreating incident, obviously, we're looking at the child and their functioning. Number 4, how does the parent discipline the child? Unrelated to the maltreating incident, what are the general disciplinary methods, concept and purpose of discipline, context, cultural practices associated with the discipline, to get a fuller picture of the parenting of the child. And then number 5, what are the overall parenting practices, reasons for being a parent, satisfaction in being a parent, knowledge, skill, expectations, parenting style, history of parenting behavior, protectiveness. So to get a very good sense of what the overall parenting practices are, independent of the disciplinary methods. And then number 6, how does the parent manage his or her own life? And there's a long bulleted list, laundry list of issues: employment, community involvement, self-care, self-preservation, etc. So the idea here is that this is the kind of information that needs to be gathered and reported to the lawyers and then ultimately the judge in order to justify or to explain the decision that's being made or the recommendation that's being made. Now, you might look at this and think to yourself it's unrealistic to collect this kind of information, this extensive amount of information prior to that initial decision. So what are, I know that you've told us, but what are your initial, I keep saying shelter care, 72-hour preliminary hearing. What's that initial hearing called in Pennsylvania? Shelter care, thanks. So you might say to yourself, we're not going to have this kind of information at the shelter care. So here's the deal. You might not. But at least let's be clear about what information you have and what information you don't have. So the court can say, okay, I can see from the petition or the affidavit that's being submitted that I have some information on question number 1, some information on question number 2, and that's about it. You need to, under federal law, make the contrary to the welfare decision at that shelter care hearing. So the court does need to say it's contrary to the child's welfare to remain at home or not in the child's best interest to remain at home. You do, however, have 60 days within which to make that reasonable efforts finding. Because part of reasonable efforts is gathering sufficient information. If you don't have sufficient information, you cannot adequately assess for threats and assess for protective capacities. So part of reasonable efforts might be the court ordering the caseworker to go out and to collect information according to the 6 questions, or whatever information is missing, make a specific order that that information go out and be collected. Certainly by the adjudication, is that what you call it? The adjudication hearing, merits hearing, adjudication? Okay. My legal expert up here, I'm looking at, yeah. By the adjudication hearing, this information, the expectation that this information ought to be collected, you've got to have that expectation. And then again, at each subsequent hearing, reviewing, even before the hearing, even before we get to the assessment of the safety criteria, whether or not this information is current and is up to date. Any questions or comments at this point about sufficient information? Please. And I'm not sure what the plan is for question. I see the AV guy panicking. Are we taping? Does she need a mic? Thank you, sir. I appreciate that.
One of the things you say for how does the parent manage his own life is mental health. We would never have a mental health eval back in 10 days.
Okay. Yeah. The quality of the information under each of these bullets is going to improve with time. Yes? When you look at the threats, which are behaviorally stated, so I'm getting a little ahead of myself here, but the threats are not case type. It doesn't read like, there was sex abuse, therefore the child is unsafe, or the parent is abusing alcohol, or the parent, therefore the child is unsafe. They're behaviorally stated. And so mental health issues come into play because sometimes there is behavior associated with the mental health issue. And I could point to examples of how it played out in this parent's life that led to a safety threat, which is maybe a convoluted way of saying you do need to have some basic information about mental health in order to be able to really assess whether or not a threat is present. Do you want to take a stab at this?
Yeah,
I feel like I'm not saying it right.
I actually think that when we get to the example, that might be more helpful in order to try to respond to this, but I'll just briefly say is that we're really not talking about that everybody goes off and gets a mental health evaluation. We're talking about something that child welfare has always had to do, which is to talk to people, to try to figure out how they're coping and how they're problem solving and whether they seem like they're alert, whether they seem like they're depressed. We're not looking for any kind of labels or diagnoses which are not really going to help inform us about safety anyway. In order for me to make a responsible referral for a mental health evaluation, I have to have already assessed whether or not this person seems to be struggling. And I may not have fancy letters at the end of my name, and I don't wear a white lab coat, and I don't have a clipboard. Nobody carries a clipboard anymore. They have iPads. But you know what I'm saying is that I have to have conversations with caregivers in order to try to figure out whether they're struggling or they're not struggling, and in what areas. And just as Jen said, in the very beginning, I may know less than what our agency ultimately will know, sometimes with the help of a mental health evaluation, and oftentimes not, because it's going to be more around the relationship building and understanding how that parent is coping in the context of their household, in the context of being an employee, a spouse, a friend, a neighbor, a sister, a daughter. So, and sons and fathers and all that sort of thing too. So, but we're going to look at an example of what we mean by sufficient information in just really a couple minutes, and that may help solidify some of the ideas that we're talking about.
Thanks. In my conversations, one of the general figures, and this is just, I don't have any research base for this, is that in some, maybe 4 out of 5 cases, there's drug and alcohol abuse related to what's going on in the family, and that what's going on when the individual's not under the influence is very different than what happens in the family when they're sober. So what I'm wondering is how much you would want to, if that's accurate, and you would know better than I if it is, then wouldn't you want to know whether there's an addiction, for example, because how much of the problem could be cleared up Yeah, I mean, in terms of, both in terms of assessing the problem, but also assessing how the problem might be cleared up and still keeping the family together.
Oh, yeah, you know, I was wondering about that. Yeah.
I understand that the drug and alcohol abuse unto itself, or addiction unto itself, is not the factor. What I'm talking about are all the behaviors that, that actually pose the risk that seem to occur when that's occurring.
Yeah,
Right.
thank you for that. Yeah.
Right. Well, we don't know each other very well yet, so I don't know whether I'm going to just be truly misunderstood by saying this, but the label of whether somebody is an addict really doesn't help me understand whether a child is safe. I think we know of addicts who keep their kids safe. And I think, now, that's not to say that I just, throw it up in the air and who cares whether there's an addiction or not. That's not what I'm trying to say either. I think what we're really trying to do is to build a body of information that we know to be very relevant to trying to understand both whether there is indeed a threat, how that threat actually plays out, at what hours of the day, how intensively it operates, how pervasively it operates, whether there's anything that mitigates that threat. We also need that body of information that we're in the midst of talking about in order to understand whether there's sufficient protective capacities by that addict parent or by somebody else in the household. So there's a lot to understand that just getting the drug and alcohol evaluation is not even going to touch. And so we can send that out for an evaluation, but I don't think that that evaluation results are going to be all that informative about the kinds of steps in this process that we still haven't even begun to walk through, of how to stay logical. It could be that the results of an evaluation like that, and I could say mental health instead of addiction evaluation, will help us understand what approach to change-oriented services might be most effective, where we want to try to marshal our resources. But in general, my own experience in not only working side by side along those sorts of evaluation services, but helping put them together in communities like Milwaukee, funding them, trying to hold them accountable, is that there is often a gap in what they provide us that doesn't help fill the kinds of steps that we're trying to take in order to make good decisions about child safety. So it's not to say that they're not valuable, but I don't really put a lot of stock in over-relying on, we can't make any of these decisions until we hear from certain types of evaluation processes. So do you want to say anything more than that?
Yeah, I wanted to punt it to you so you could be the one to say that about because it is a little provocative with regard to the mental health as well as the issue of drug and alcohol abuse and addiction. But as you were speaking, I was thinking maybe a way to make it a little more palatable to folks is to say that the correlation, I don't know how you feel about this, I just thought of it while I was sitting there, so you never heard me say this before, but the correlation between someone who is a serious addict is and creating a condition or having a condition in one's home that's therefore unsafe is high. But there's not, to think that because one is an addict, therefore the house is unsafe is a thinking error. And we haven't rigorously defined at all yet what we mean by a threat. And so I think this will be illustrated a little bit better. So it's not that we're crazy saying that it has no bearing. Of course it does, but it's not a therefore kind of thing. So the correlation is high. Okay, does that help? Yeah.
I'm not advocating what you were saying,
Yeah,
one thing therefore another, but I'm talking about a situation where you have identified there's danger to the child,
yes,
and you've also identified that there's serious addiction. I guess in my way of thinking, I would be surprised if there's a solution that doesn't, there might be, but that doesn't especially if the abuse is occurring or the dangerous situation's occurring during periods while the person's drunk
Using.
or high.
Yeah.
So it just struck me that that would be something that might be, in most circumstances, would probably have to be a component
yes.
of the solution, that's all.
Yeah, agree. And it's a very good question. And continue to think about it as we distinguish the concepts and ideas. So yeah, now, we're moving from what we call an incident-based approach to an identified threat approach. And remember I said earlier that we focus on that maltreating incident, and I'm not saying it's not important, it is important, but what we're not doing, or what the legal community is not doing, is taking that information about the maltreatment and what occurred and looking at all the other information that's relevant to this family's functioning and identifying whether or not a threat is present. Now, social services is doing this. We did have a look at your, some of your forms prior to this presentation, and a lot of these concepts and ideas are embedded in the forms, including the idea of threat, an identified threat. But very little of that gets communicated up to the court. And I conclude myself in this when I say before I started working on this book, in fact, I really didn't know that there was this concept in social work that Terry said to me at one point, well, all social services agencies have a specific list of threats. They may look different, they may not be behaviorally stated, which we recommend that they are, and by the way, Pennsylvania's are. She said, but they're all there. I said, no, they're not. I don't think so, not in the court I practiced. And she said, well, why do you say that? I said, well, because they never were communicated. I was representing kids. I said, I never saw, what I saw was a detailed description of the maltreating incident. I didn't see the identification of the threat, which is a very different thing. And it kind of begs the question as to why not. So it's something to think about. But the point is, we're moving from looking at going from an incident-based approach to a threat-based approach, which is the identification of the safety threat and focusing on that. And focusing on that, why? Because that's part of the definition of the unsafe child. So we haven't yet looked at the threats, and that'll become more clear when we do. So insufficient information leads to poor decisions, leads to poor outcomes. So that should be obvious at this point. So Terry's going to walk you through an example, a specific case example of what sufficient information would look like.
Okay, so let's stop talking about the 6 questions and the bullet point examples and look at what we really mean, so that you're not thinking that we expect everybody to write a book about every family. There's an example that is in the actual copy of the guide that you have. So if you'd get that out, if you don't have it already in front of you, and turn to page 5, 6, and the top of page 7, we have an example. By the way these chapters in this guide are laid out are similar, is that whatever the topic is for the particular chapter, this one is about information driving decision making, we have a bit of narrative to explain what we mean, and then we stop very often throughout all of these chapters and have a shaded text box that, since you've got it in color, it's in green. I usually have to say it's in gray because, you know, the state did it in black and white. So you have green, and where we thought it was important to stop now and again, talk about it in as plain a language as we possibly could put together, and give you an example of what we're talking about so that you see the application of the concepts that we're talking about in each chapter. So here we have laid out a case, and before I'm going to ask you to take a look at it, I want to set it up so that you know what time frame in this case you're looking at this. This case is a real case. Obviously the identifying information has been changed, but this is the way the case was written about. It was not in time for the shelter hearing, if that's what you call your emergency custody type of hearing. What happened was the call came in. This had been a case that had been open with a large urban child welfare agency some time back. It had closed, and the agency was not involved with the family when this new incident occurred. The prior foster parent who had remained involved after the case closed remained involved as a helper, not as somebody trying to, sabotage success or anything like that. But she had remained a helper to the birth mom, and she let the agency know that this new event had happened, whereby the mom had confided in the foster parent that in order to get the kids to sleep at night, she had given them some sleeping pills. And so that incident got called into the agency. The agency went out there immediately, got the kids to the doctor to see whether or not there were toxic levels of medication in the kids' system. There weren't, but it was a pretty scary time, and complicating it was that the mom, in meeting up with Child Protection at the front of her house again, after having all the kids previously been in foster care, was hysterical and was not really wanting to allow access, was screaming and saying that she was going to leave the state with the kids. And so it was sort of a hectic time, and the children were placed on an emergency basis. They got they had to call in and got judicial order to do that, and the kids went to that previous foster home where they had all been. There was what they called an emergency custody hearing. This information was all not known at that point because it was only 24 hours later in that particular jurisdiction. That was when they had their hearing. But within about 7 to 10 days after that emergency hearing, the worker on the case collected the rest of the information. Some of the information is an allusion to the historical record that the agency had, but you'll see where it talks a little bit about history, but also talks about what's going on today. So what I'd like you to do, actually, I'm going to shut up now and ask you to scan these couple pages here so that we have a baseline of what we're talking about when we mean a sufficient body of information upon which to make further decisions. Really, the description of the mother's functioning, I think, is a good example of what we were talking about before. You see how there's a label of bipolar, but it really tells us nothing. But the worker attempts to describe what that looks like on a day-to-day basis or even within a day. What we like about this example is this information was collected by a bachelor's degree social worker who had been working for the agency at that time, like maybe about 10 months. And it was collected not just happenstance because he came from some other kind of background or a different kind of agency. He was working at an agency that was attempting to implement a framework for what information is important, what information is pertinent, that we need to know about every family in order to understand whether we need to serve them, even if there's been an incident that came to our attention that in the very beginning seems pretty serious. What else do we need to know besides that incident? In addition to working inside of an agency that was trying to hold coach workers to do this regularly and give them the type of skill set that they need in order to collect it, but they were also working with their court system to work at how can we all agree that this is the information that is pertinent, so that even though the only hearing that he had been through at the point, but prior to collecting all of this information, was the emergency hearing, and he couldn't have known all of this information at that point. at that hearing, part of the sort of the boilerplate order that came out of the emergency hearing was to tell him, the agency, as well as the family, as well as everybody else who was there representing different interests, is that more information needed to be gathered in order to revisit whether this one incident was indeed part of a pattern. So, I mean, the boilerplate order didn't say it that way, but that just basically, we need more information, and we need more information about how the kids are functioning, how the mom is functioning, what the parenting is like today, etc. So that was part of a boilerplate, which sounds like, big deal, you know? But what happens is that when we're working with jurisdictions, providing technical assistance around implementing aspects of the guide, Jen's colleague Timothy Travis and I have done some focus groups with child welfare staff in another state who are saying, I am now for the first time being asked when I come into the courtroom some questions that I've never been asked before. And what came out of these focus groups was that in this particular agency, they were expressing, the staff people, were expressing some longing for more support and more coaching from their own agency, better preparation to collect this kind of information. Some of them expressed dismay, having not been fully prepared to walk into a courtroom one day and being asked some questions that they could have known, but you know, the agency was having some communication problems. And so they didn't know. But what they said was, I don't intend to go back in that courtroom and be asked those questions again without having the answers to them. So now does that, like, is this like the magic bullet? No, of course not. But it addresses some instances where, as a former director, where I was trying to implement certain standards of practice with my staff, and being frustrated that sometimes staff would come back to me and say that my own agency's attorney was telling them that information isn't important, don't talk to me about that. Or that in a certain courtroom there was a different way of doing business, and what I was trying to ask people to implement wasn't going to fly in so-and-so's courtroom. This is trying to come together with some idea of, can we arrive at a framework for understanding what the pertinent criteria are? And it begins with this foundational step of, beyond that emergency hearing when all heck was breaking loose, since I don't speak French, is, you know, and the helicopters were overhead and everybody was going to jail and I had 6 kids to have to place in the middle of the night. No, I'm maybe not going to walk into the next hearing with an awful lot more information than the incident. But what I'll tell you from having gone through this process just recently and now going back for tomorrow in Milwaukee is that this group of 10 leaders in Milwaukee sat around a table with us, and for 3 days we read emergency hearings, temporary physical custody hearings is what they call them, read it and looked at the level of effort that got made, because what the child welfare people were able to say to all the legal people in the room after reading these cases together is that very few of these cases are cases where I have to run in with a flak jack, or that there's helicopters, or everybody's going to jail. More times than not, it's an emergency, but there's time and opportunity to collect more than just the incident. There is opportunity to know somewhat more, and maybe that would help us understand how much more complicated this is likely to be or not. So anyway, so this is the example. Now, I guess maybe this is time to say, having read this, do you have questions or comments about whether this seems like this is insufficient information, it's more than anyone should really be asked to gather? Anything? Yes.
Just talk loud. Was she responsive to direction, like as far as if said you can't be giving her sleeping pills, but she seemed to be willing to sort of accept, some minimal level of counseling. It is on. Okay.
Oh, right.
Was she responsive to direction?
Well, we haven't even begun to decide whether, based on this information, there's any threats. So we're not really directing her about anything yet.
About like, don't give them sleeping pills?
No, right now, at this point, we're at like about day 10 in the case, and the kids are sitting in the previous foster home under a court order. So we're going to walk you through, and we're going to come back to this case in a couple of examples to look, which is why part of the reason why I wanted you to get a good dose of what this case is about, because we'll look at this case again in terms of, besides the event, which was serious, but besides that, do we believe that the kids would be in any danger if they were back in the home? And we won't be looking at whether or not we can just tell her not to do that again. Right. So, any other comments? Questions? All right. Well, let's see how far we can get before we need to take a break. That math formula that I showed you that looks like that. This slide is just the definitions of what constitutes a safe child, what constitutes an unsafe child. It's that math formula set in prose. So it's vulnerable kids are safe when there's no threats, or, and this is an important or, they've got caregivers who possess sufficient protective capacities to protect them, even in light of any threats in the home. Unsafe children are unsafe when they're vulnerable, there's threats, and there's insufficient protective capacity in the home. So, we're going to take apart these three key concepts, threats of danger, vulnerable kids, protective capacities, so that we're sure we are all on the same wavelength about what we mean by them, but also that you can see how, by collecting the answers to those 6 categories of information, we're using that as the foundational piece, and then there's criteria and definitions of what we mean by what constitutes a threat of danger, what constitutes a vulnerable child, and what constitutes sufficient protective capacity. So let's take a look at this first idea of threat of danger. On page 10 in your book, we have a list of 3, 6, 9. How many threats do we have here? 15?
Yeah.
Yeah, it's been a while.
Yeah.
15 threats, which are not meant, I promised you that this isn't a practice model. We're not saying by listing these threats here on this page 10, and we have them on one of the bench cards that you have as an easy reference guide. We're not saying that, if you don't have these threats here in Pennsylvania, you're doing something wrong. They're meant to show you that these are the most common set of standardized threats that are used throughout the country by child welfare. There's more agreement in child welfare today about what constitutes a threat of danger than there's disagreement. And that was not always true when it came to the 80s, and child welfare liked to have lots of arguments about who had the best risk assessment model. And maybe you guys participated in that ongoing debate. But when it comes to what might be a family condition, and by condition, I mean those sorts of behaviors, emotions, coping skills, coping style, motives, perceptions that are out of control. It could mean that I am not even conscious of them. It could mean that, yes, they are, but they're part of who I am. It could be that I acknowledge that this is the way I behave or emote, and I really want things very sincerely to be different and promise you that they will be different. but we're going to look at what we mean by they're out of control. They're out of my control. They're out of my family's control. Tomorrow, I don't want to be so depressed that I lie in bed all day and don't properly supervise my kids. I don't want to be in this kind of pain. But tomorrow comes and I sleep all day. I don't have control over it. I don't have control over my addiction. I don't have control over my immature impulses, my gambling, my use of resources, whatever I'm spending it on, instead of food, clothing, shelter, level of proper supervision, protection from severe harm of my kids. So we're looking very closely at whether or not this condition that we're worried about is out of control, whether it's playing out right in front of me as I'm standing there in the family's living room, or whether I'm learning enough about the pattern of this, and this sort of speaks to sometimes people's usage. The worker knocks on the door after a very serious report that comes in saying mom drinks all the time or uses heroin or whatever. I knock on the door, mom is there, she's clean, she's sober, the kids are there, they are not afraid of her, there's food in the pantry, what's to worry about? So we're looking at trying to get beyond the report, the incident, or the allegation, and trying to collect enough information to understand whether I or the caregiver behaves or emotes, or there's other sorts of conditions that are happening that are out of control, that might be playing out right in front of me, or will be playing out in the near future. Now, we don't have a magic date, but we're looking at in the coming hours, days, even weeks, that it will play out, and without any type of way of trying to get control over this uncontrollable condition, it will lead to severe consequences. And here's where there's probably a pretty perfect matchup with the kinds of statutory definitions you have for different kinds of abuse. Because we're talking about severe consequences, meaning not just that somebody doesn't make enough eye contact with their kids or get their kids immunized or go to parent-teacher conferences. We're talking about broken bones and lacerations and egregious sorts of incidents that could ultimately result in death. So that's what really separates the risk type of assessment that child welfare used to do in the 80s, absent any kind of assessment of safety, and trying to look at, besides any type of risk assessment that might be done, let's look at whether or not we are worried about child safety. Now, I think there is general agreement when we all say what we think is a threat of danger about those sorts of wild and crazy things that you either hear about at your shelter hearings, that were the incident that led to coming before a shelter hearing saying why the child needed to go to a different bed or somebody needed to move. Or you read about it in the newspaper or online or on the TV news, the kinds of everybody is busted for drugs and they go to jail, or a child is found in a closet and hasn't been fed in weeks, those sorts of things. But what we know about nationally is that less than 5% of all of the reports that come into a child welfare agency through their hotline or phone intake system, less than 5% of those when we go out is it that kind of a case. Those types of threats of danger are usually fairly transparent, they're very vivid, obvious, probably don't need a social work degree in order to identify them. The average person on the street could probably identify them, that somebody needs to do something about these kids right now. But if only about 5% of our data shows that that's the type of incident or that's the type of threat of danger that's operating, does that mean that the other 95% of the cases that child welfare goes out and responds to, that all those kids are safe? There's no threat of danger? I think, if you just think through logically, that can't be so. I mean, even if you were trying to sort out who's a good daycare provider for your own child, just because you walked to the family daycare home came in the living room and nobody was waving a pistol with drugs all over the coffee table, that you would say, well, this will be a safe place for my kid. So we look at this in a two-pronged kind of way. Is sure, there's threats of danger that operate. And you can look at this list of threats, or you can look at your own list of threats that's used here in Pennsylvania, and that's at the tail end of this book. If you've never seen them before, you should take a look at them and do a crosswalk of, you'll see many of the threats that we have listed here. Just as we said, they're here in Pennsylvania. And they're behaviorally stated, and there's definitions for them. But what we want to separate out is, let's not then lock into thinking that these threats, whatever the list is, that they only operate in that vivid, crazy kind of way. Yes, they can operate that way, but what might I need to know about a family in order to understand whether someone who meets me at the front door, who doesn't look like she's terribly depressed or is struggling with the use of alcohol or other sorts of drugs, or is fairly immature in her parenting decisions, leaves at the drop of a hat whether the babysitter is there or not. If she's not doing that right in front of me, what do I need to know about this family in order to appreciate whether there are children in this home who still are residing in a state of danger? Because we can collect information about the allegation and miss sight of what we call impending threats of danger. That's the not wild and crazy stuff, but just as serious, just as likely to play out in the very near future, and when it does, it will lead to severe consequences. So we look at this list of threats, and we supply for you in the back of the guide on page 55 and in the ensuing several pages, we have what is called Appendix A, and it says a little bit in the very beginning of what I just talked you through, is that threats of danger play out in a couple different ways. One very vivid and transparent, another in an insidious way, demanding better information collection. It is why that judge in the Casca case at the shelter hearing ordered more information collected. What he knew, that judge, was that on that day, that event, there was something wild and crazy going on. But what if we wanted to think about if the children could return home, maybe she would never give them sleeping pills again. Is that really what this is about? Or do we need to understand whether there's insidious types, impending danger that we need to be thinking about whether or not they need to be controlled? So the lesson here is more about making sure you are doing the crosswalk. Child welfare folks in the room know what your threats are. Everybody else, have you seen these threats before? Are they used in order to justify, to help explain what the decisions are, why a child needs a safety plan, whether it's an in-home safety plan or an out-of-home safety plan? Are they talked about in terms of whether or not children can be reunified? This is part of the standardized criteria that the logical framework we all should be using. When you look at that math formula, what you'll see about an unsafe child is without a threat, we can't get to the conclusion that there's an unsafe child. You need to know what these threats are. You need to find out what the information is that supports either the existence of these threats or the absence of these threats. Either way.
I think, yeah, we're close to a break, but that's actually an excellent question. So instead of having it be rhetorical, maybe during the break, and we can start at the beginning of the next session, taking some comments on that. If you go to the very last page and you see Pennsylvania safety threats, and as Terry said, now you've got 14 and we have 15. If you were to do a crosswalk, they line up pretty well with the safety threats that we have in the guide. And so in answer to the question, the gentleman's question up front about the drug use, if you look, of your 14 threats, you don't have the parent is abusing drugs, but you see the use of drugs and the impact of the use of drugs and alcohol expressed. Like if you look at the criteria and the criteria that explains how you get to establishing whether a threat is present or is not present. Like number 6, for example, the caregiver cannot or will not control their behavior. And then you look at the criteria and you see the caregiver's under the influence of some substance and is unable to control the effects of the addiction. So the way your threats are laid out actually does it quite well. Number 5, caregiver's violent, acting dangerously. And then you look at the criteria that includes reference to drug use. So do you see what we're saying here is that in stating the safety threat in a behavioral way, and by the way, that's going to help us later on tell us what to do about it. Because we're very clear about what the threat is, and it's stated in a behavioral way, and therefore we know what the impact on the child is. So I'm thinking we ought to, they told us to stick to the timeline, so yeah, so so do that on the break, is take a look at those safety threats and then come back and let us know, especially if you're a judge or a lawyer, whether this list is something you're familiar with and that these threats get presented. I said break, and all of a sudden people stand.
I know.
Terry
Wait
has
a
one
minute.
more
I have
thing.
one more assignment for you during the break. This is a little bit shorter, I think. On page 10 and on the top of page 11, there's one of those text boxes again, the shaded box. It's the Koska case. Take a look at what the identified threats are, and you'll see that it has very little to do with the fact that she gave them sleeping pills. So we use the answers to those 6 questions now to understand what the threats of danger are, not the night of the incident, but now that if all these people were living together, what are we worried about? So take a look at that, and that might help put some of this together in a more practical way. Okay, 15 minutes?
Yeah.
15 minutes, so look at your watch right now. We made a promise to ask you if you had anything that you wanted to either say or ask about regarding this first element of these 3 elements making up the decision about whether a child is safe or unsafe. So having walked through the idea of threat of danger, 2 different ways that it might present itself, the kind of information you would need to know, the fact that threats should be behaviorally stated. The reason for that is if they're organized around type of maltreatment or something that is a label, like mom is bipolar or mom is an addict, that when it comes time to trying to figure out how to put a plan together that might control it, those labels, those non-behaviorally stated ways of expressing ourselves about what we're worried about with respect to a threat, they don't help at all when it comes to then putting together a plan. So we showed you what your list is like, how it compares, contrasts to what we believe are some of the more common threats that are used across the country, the fact that every set of threats ought to have definitions, give you lots of examples of different ways those threats might play out. And then finally, right before the break, showed you how on the Koska case, the worker doesn't get seduced by the incident of the sleeping pills and thinks about, okay, those kids right now are safe. They're with the previous foster parent, but we're on day 10 of the case. Now that I know everything that I need to know in answering those 6 questions, how does this, what does this mean in terms of the more insidious type of a state of danger that the children might be in if everyone was together? And you saw that the worker picked out that the behavior is dangerously impulsive, they cannot control their behavior, that they're lacking parenting knowledge, skills, and motivation, and that has little to do, as I mentioned right before the break, with the sleeping pill incident, and more about her way of functioning at large. So, we're prepared to move into the next element of vulnerability and then protective capacities, but let's just make sure that there aren't any threats. Let's make sure there's no threats too, okay? But are there any comments or questions about this concept of threat of danger? Okay. I'm not going to spend, in the interest of time, a great amount of time on the next piece of this math formula, child vulnerability, except to point out where we talk about it in the guide, page 11 and page 12. There's also probably a bench card on vulnerability, isn't there? Yep, bench card C. But we have an example of a vulnerable child, and we have deliberately taken a slightly older child, a slightly more assertive, bright, maybe self-protective in terms of stranger danger or the coach at school or whatever, that kind of being able to protect herself, but show you how in the way we think of vulnerability, which is having to do with the degree of dependence she is on the people when she walks in the back door. So while a child might be, certainly, you know the basics, the younger the child, the more vulnerable they are, little kids, kids with all sorts of different abilities, and whether or not that means that they can protect themselves. But we are talking about any child, regardless of age, and what life is like for them when they walk in the back door at night, and whether or not the kinds of things that we tend to easily slip into in giving kids who are older business cards, or having that standard kind of conversation of, is there someone in your life you could talk to? Who would that be? When would you call them? Do you have access to a phone? That sort of thing. Is that the things like family loyalty, worries about what might happen to me, to my family, those things make kids vulnerable just as much as little bitty kids or kids with differing abilities. So we're always looking at the vulnerability in light of having gone through identifying what we think the dangers are. So we've got the obvious vulnerabilities and the less obvious ones, and then the example, as I mentioned to you on page 12, in order to take a look at how that's applied. And I think I'm going to turn the next piece over to you.
Okay, great. The example's on page 12 if you want to read it on the vulnerability. So protective capacity. So remember the math formula. Do I have it here again? I do. That definition of an unsafe child is a threat is present, the child is vulnerable to the threat, and the family lacks protective capacity to manage the threat. So you could think about the protective capacity as strengths, family strengths. Now, you might hear when I say family strengths, things like, does the mom have a job? Does grandma live nearby? And while these things are important, it's not what I mean by protective capacities. Protective capacities are personal characteristics associated with being protective that indicate vigilance, preparation, and the power to protect. So we divide them into three categories. And if you pull out the bench card D on protective capacities, and there's a corresponding chapter in the book, and then Appendix B, much like the way that we have definitions of the threats of danger in the appendix, this appendix is definitions and examples of protective capacities. So the first type is cognitive protective capacities. So this referring to knowledge, understanding, perceptions. And the examples, and for each of the bulleted examples that you see on the slide, each of those bullets, there are 4 or 5 sub-bullets underneath them to give you a richer understanding or different ways of looking or different things to consider with regard to the parent. So does the parent articulate a plan to protect the child? Are they aligned with the child? Do they have adequate knowledge? Are they reality-oriented? So can you see, even from this first list of general cognitive protective capacities, how important it is to have the answers, the information to those 6 questions so that you can have some sense of who this parent really is and whether or not he or she possesses protective capacities. The second type, behavioral protective capacity. So it's not enough to know what to do. Does the parent do it? Actions, activities, performance. Are they physically able? Does he or she have a history of protecting others? Do they act to correct problems or challenges? Do they set aside his or her own needs in favor of her child? So again, we were talking about the issue of drug use earlier. You might say that not only does the drug use pose a threat because when the parent is under the influence of drugs, when mom is under the influence of drugs, she's acting impulsively. She's placing the child in dangerous, unsafe conditions, exposing the child to violence, etc. But also, that issue is relevant to the assessment of protective capacity. So here, does the parent set aside his or her own needs in favor of a child? Well, the answer to that question while she's using might be no. So you're using the information that you have to assess the presence or the absence of protective capacities, or to what degree they're present or not present. And again, when we're thinking later on down the road about what the family services plan should look like, part of the goal of the family services plan is to enhance the protective capacities. So let's get clear early on about what they are and what the gaps or the deficits in the protective capacities are. The third type of protective capacities are emotional. Feelings, attitudes, identification with the child. So we're looking at 2 issues, the parent-child attachment and the parent's own emotional strength. Is she able to meet her own emotional needs? Does she intervene to protect the child? Does she realize her child cannot produce gratification and self-esteem for her? I think that's hard for all of us that are parents. Is she tolerant as a parent? Does she display concern for the child, bonded with the child, express love, empathy, sensitivity? So we ask ourselves, how do we know whether sufficient protective capacity exists? So it's not a matter of good intentions or sincerity or an interview with mom where she breaks down sobbing and tells you how much she loves her child. No, we're looking at credible evidence, information from the 6 questions to demonstrate the absence of or presence of the protective capacities and to help identify where the gaps are. So if you look on bench card D, in addition to the very truncated list of examples of how we might assess for cognitive, behavioral, and emotional protective capacities, there's prompting questions that the judge could ask or the attorney preparing the case could ask. And you can read the questions for yourself. I'm not going to read them. And then the parenthetical tells you which of the protective capacity that's designed to elicit. And then this slide sums up some of the essential ideas about protective capacity. Does the parent understand the threat? You know, it's not that, I mean, we may even think about some of our own homes when we were children, or our homes for those of us that are parents. It's not that there are never threats present. From time to time, there are threats present in some homes. But you probably were safe as a child, or perhaps your children were safe because there was someone within the family who was managing the threat. That's protective capacity. There was someone who was looking out for the child that kept you safe, that kept you protected from the threat. So does the caregiver understand the threat? Do they know what they're going to do to manage the effects of the threat, and do they do it? So again, it's not mom breaks down and promises never to do it again or that kind of thing. No. Do we have evidence that the protective capacities are there, and there's a history of the parent demonstrating that kind of behavior? Any questions on protective capacities or where we are so far with distinguishing the three components of safety: threats of danger, vulnerability, and protective capacity? Thank you.
In assessing this protectability and looking at threat of safety and contrasting these two examples, how do you look at whether or not there are services in place or could be put in place as part of this analysis?
Yeah, that's
You know,
a beautiful
in the
question. Yeah.
first case,
Yeah.
what seems to be missing from the Kashka example is what happened during the 7 months since this case was closed. Right? Obviously, the children had been removed. The mother made progress enough with everything she was doing to have all of her kids returned to her, and then eventually enough progress beyond that to have the case closed. And so I think you'd look at that case very differently if she had been continuing with services, had therapy, had whatever other support in that house, and still had those issues arise, versus if she had been just without services during those 7 months, such that you already know that family as a caseworker, hopefully, you, or that as a system, as a judge, as the GAL, and you can see what happened before. If you put those things back into place, there might be absolutely no reason for removal, or you might have significant concerns depending upon that. So she was getting respite care, she was looking at getting support for herself. How was that used? And then looking at this case, you have different age, of course, but it also highlights the difference. So the second question I have is, do you look at applying these differently in cases that are returning cases, where you have a lot of history and information, and new cases like Katrina's?
Okay. I'm not sure I understand the second question, but let me take a stab at the first question and then have you repeat the second question if it doesn't get answered. First of all, I like it because it's a good segue to where we're going. You could look at the services that are provided as part of their purpose is to bridge that gap where the protective capacities are missing. So if what I said earlier is that the purpose of the Family Service Plan is both to reduce or mitigate the threat and enhance the protective capacity, and we're about to talk about safety plans in a minute, which your question touches on as well, because that's what the safety plan is, right? Keeping the kids at home. In the Koska case, you know, what would it have taken, I mean, hindsight's 20/20, but to keep the kids at home, what kind of in-home service safety plan would have, could have, should have been in place that would have avoided that happening, right? But you could look at the services that are provided as bridging that gap for the deficient protective capacities. That sounded a little academic. Do you want to, let me have you repeat your second question.
Well, they kind of relate. I mean, and
Yeah.
this part is, as you're evaluating, it's not just the protective capacity, it's not just the safety plan, but if you're going to evaluate the threat or risk, you need to know what worked and didn't work before. And so if you had services in place that kept children safe because you knew the history of that case, you would need to bring that to bear in the Koshka case to say, this family could be safe if we put those same services back. You can evaluate the level of risk and threat better in case one than case two because of your history with that case.
I see what you're saying
In
now. I'm
case
not sure I
two,
agree.
and then how do you look in case two? Do you look at cases differently was the question, when you have all that history versus a new case that you've never seen before?
Not differently in terms of any of these concepts. What I think is that in some instances, there's more information available to help us understand the answers to those 6 questions, so that I'm not just relying on the family system themselves. There's other eyes and ears, including other service providers, who might give me information. But I certainly also don't make a judgment that just because there were services, and I know you're not saying this,
Yeah.
it's just that it's complicated by the fact that so many of our services, at least where I've worked, are somewhat ineffective. That there's not a really good relationship built with understanding who these people are. So that there's more, and that a lot of service providers have been kind of trained by all of us to believe that what we're interested in is more about their compliance with services than anything that really is telling us how they truly are functioning as a 35-year-old woman, not as a consumer of the service, not as a parent, not as a customer of child welfare or the court system, but who is this woman? So I guess I would say is that a history of services in and of itself would tell me little to nothing, except that there's been a history of services. It's what's the quality of that information, and how does it help me understand how Mrs. Casca is operating today. By the way, interestingly, is Mrs. Casca was not involved with the court system because one day at a court hearing, the judge was frustrated and sent all 4 children home that day. And court supervision ended that day, and the agency was ordered to end its involvement. So the fact, I mean, I think you're raising something that is interesting, is that the fact that she was able to make it for the 8-9 months without a new report speaks volumes about something must be happening here where she's at least getting by. But I don't know that we want to use the threshold of a new report to the agency as how we're going to put our finger on that pulse. It's more the answers to those 6 questions about not just how these kids were functioning at the last time that the agency had contact with them, but really how are they functioning today? How is she functioning today? Can we not get seduced by, you know, what her history was like and look at what her functioning is now? Just remember, we're at a point where we're walking through something probably painfully slowly, but something that is happening in the first days of this case. We're not trying right now to put services in place or try to figure out whether or not there were services and get our hands on putting those services back in. We're looking at, we got these kids right now under the umbrella of that previous foster parent. They're in a safe bed for now, but we're trying to understand whether or not they still need to be there, whether there's any reason to believe there's any threats at all, and even if there are, we're going to walk through whether the kids are vulnerable to those threats, and if they are, and assuming they are, then is there someone in the home who's not a source of the threat who can protect? Now, in this case, Casca, we don't have another caregiver. So you can't be the source of the threat and the protective caregiver all at the same time. Won't work. But these are the elements that we're going to walk through, and in just a moment, then get to the point of, then are the children continue to be unsafe if they were all back together? And if so, what are we going to do about it?
You know, why don't we do this? It's just this one before you
Okay.
start, so maybe grab
Yeah.
that bench card E.
All right.
So, really what this slide is saying is it can cut both ways. That's what we mean by it's both the sword and the shield. So, on the one hand, kids who are not safe can be protected because, as Terry said, most cases do not come in with the helicopter overhead and got to run in with the flap jacket and grab the kids, right? But most cases where there's a threat, it's an impending threat, and we have to get better at recognizing that despite what we see in a 20-minute interview in the home, that a threat is present. And we don't know that without doing our homework and collecting the information on the case. I hate to go back to something that was said earlier because we need to move along, but one of the things I used to, just as a lawyer, accept that, well, gee, you know, there really isn't enough time by the time we get to the shelter care hearing. And as I've been doing this work and talking about, well, how much time was actually spent at that initial interview, and, you know, you get answers like 20 minutes, a half an hour. And I was talking, doing some work up in New Jersey, and someone said, well, the CPS worker stays as long as she needs to get the information that the court's going to ask her. It was almost like, you know, the worker wasn't really there under a genuine inquiry to find out what was going on in the family. It's just, what do I need in order to get this child removed? And it sounds a little cynical, but I think once we start uncovering the amount of time that gets spent gathering the information before these recommendations are made and asking ourselves, is that really reasonable? It's a little bit of a provocative area. So the question we pose here, well, what's the cause of unnecessary removals and tardy returns? And we submit that to some degree it's uncertainty caused by a lack of evidence and a consensus about how it should be applied. And said a little differently, but maybe a little easier to understand, is the idea of better safe than sorry. So why don't, I'll turn it back over to you to cover the issue of, at this point, if you would take out bench card E, and we'll walk you through the process that summarizes everything that we've just said so far.
Oh, here you go.
Oh, sorry.
That's all right. Yeah. You don't want to mix them up with my bench cards. Okay, so if you look at bench card E, this is the flow chart of what we were just walking through. Is that this elliptical, until I started doing these presentations around this form, this flow chart, I don't think I used elliptical since I was in 9th grade geometry class. But this elliptical, where it says when sufficient information is collected, decide if threats of danger exist. Now, let's not confuse this with the early on decision when that worker knocked on Casca's door and discovered that, yes, indeed, she did give them sleeping pills. Not then. So he did what he needed to do to try to secure the kids' immediate protection while he gathered more information. And it was around somewhere between day 7 and day 10 after the emergency hearing, the shelter, what you would call a shelter hearing, he collected that information that you read about. So that's where this little flow chart begins, is once I've got enough information, now I'm going to think about, are there threats? So it's no longer the incident on the night of July 19th. It's about using that list that you have with the behaviorally stated threats, with the definitions, and justify. What's your information that tells you that any of those threats would exist if everybody were back living together? And in a great many instances, child welfare has to make this decision without having taken anybody into custody or an emergency placement somewhere in the middle of the afternoon or the middle of the night. Most of the cases, like I said before, this still needs to be addressed by the time that initial assessment or investigation process is finished. I now have enough information, not just the allegation, in order to understand whether there's threats. And you see why we were saying to you, it's important that you know what those threats are, and it's important that you know that danger exists at an impending level and not just the wild and crazy kind. Because if there aren't any threats, look at that first box, the child is safe. So if we had reached this conclusion that and we didn't, on Casca, you saw what threats the worker identified, but if there were no threats, those kids better come home now. Here's where greater precision around safety decision making will start influencing children's right to permanency. So if no threats, the kid's safe. But if there are threats, we walk through the rest of that math formula. Are the kids vulnerable to the threats? If they're not vulnerable, not highly likely, but possible. So we owe it to families to walk through a methodical process. This is not extra work. This is using the information that I know about how these kids are functioning, bumping it up against the identified threats, and justifying to you, if I believe the kids aren't vulnerable to these threats, I should be able to describe to you why. But if they are vulnerable, then we've got what Jen just walked you through regarding this North Star of the rest of the intervention process. This is why kids stay safe in America, is not because there's never any crisis that rises to the level of a threat of danger. It's because they have people who are taking care of them. So we're going to look at whether or not, in spite of the fact that there are threats and there's children who are vulnerable to the threats, do we have sufficient protective capacity? The 6 questions that are posed that we walked through so painfully slowly this morning, or this afternoon, just felt like this morning, is that those are open-ended questions. It's not like, what's all the dirt you can give me on the way these people parent? It's about, what's their parenting like, positive and negative. So it should provide both things that might rise to the level of a threat of danger, as well as those things that are characteristic of either cognitive, behavioral, or emotional protective capacity. If we have sufficient protective capacity in this home, then the children are safe, like they are in most homes. If we have insufficient protective capacity, then we have an unsafe child. Now, the idea here is, and that's what the slide is, now what? Okay, so now is it all about, let's dump a whole lot of services on these people? Anger management classes, parenting classes, psychotherapy. If she was using, there's an allusion to that she used to smoke pot in order to cope with her feelings. Let's have her go, pee in a little cup, and then that'll tell us what to do next. This is about, we're going to try to put a lid on things. I want you to think about a threat of danger, particularly an impending threat of danger, as though I've got a frying pan on the stove with some oil that's getting so hot that it's starting to spatter. And what I want to do is immediately, if that's what I walked away from the stove for a moment, and now I've got this situation on my hands, is that a safety plan puts a lid on it. Underneath what's going on inside that pan is exactly the same. You can put your ear down towards it if you don't burn your hair, and you can hear what's happening underneath it. But we've got a lid on it so that there's no more spattering. Now, if I take the lid off, all the spatter starts all over again. If I turn down the flame, or if you've got an electric stove, it's going to take a little bit of time, so it's even a better metaphor, is that I turn down the heat, and that is maybe what you should be thinking about as being the difference between your family service plan, is that what you call the change-oriented plan, and what we're defining as a safety plan. It's easy to think about foster care, 100% out of home, sleeping at another address with other people who have been licensed by us. That's a safety plan, right? It's a safety plan. It's the most intrusive safety plan we can come up with. And there's a whole lot more that we can go through to try to decide whether or not, does it really have to be that? Can it be an in-home safety plan? Can it be something that's in between? There's been, some conversation about what's Mrs. Koska been doing, for heaven's sakes, the last few months. Well, with the help of, that was the previous foster parent. It could have been in a different family, a neighbor, a family member, somebody who's trying to help her out, give her some relief. That is intermittent out of home. So we're really trying to stay away from this it's got to be one or the other, and look at how you would probably make arrangements if you suddenly had a medical condition where you had to be flat on your back according to doctor's orders and you had a 3-year-old. Well, some of you might say, I've got nothing to do except send my child away to my mother's house. Others would say, my mother would move in. Others would say, I don't want my mother to move in. No, no, no. but you'd find a way so that you'd stay in contact with your child as much as possible. And if that meant neighbors pitching in and bringing over food because you can't even get out of bed and cook meals, then that's what you do. And what we're asking for is the same level of effort to at least think about and justify what will be sufficient and feasible and sustainable to control for safety in the Casca case. So let's think about this issue of what's a safety plan and how it's really very different from the sorts of things, how you should never see in someone's presentation to you as, here's the safety plan I'm recommending. Things like parenting classes, anger management classes, drug treatment. Those might all be needed, necessary in order to turn the heat down. We're looking for the size lid to this frying pan that's going to adequately keep control over this and allow us time to try to figure out what change-oriented services are really needed. So we're looking at fairly concrete kinds of things. The more esoteric, the more insight-oriented things sound, the less likely you're really looking at a safety plan. This is trying to insert into that math formula, if you remember algebra, and who doesn't really, is that you are going to put where there's a minus protective capacity in that math formula, we're going to put a plus sign there in order to make this kid temporarily safe through the use of a safety plan. So what's gonna do it? Obviously, 100% out-of-home care with someone else where there's a safe environment, of course, that would substitute for it. But can't we go through a process that uses the same type of logic and critical thinking principles that we've been spouting about the last couple hours? So take a look at, if you would, it's on pages 22 and 23 of the guide. It's also on a quick and easy bench card reference sheet, bench cards F as in Frank. We don't list, like, obviously names of whether it's national or local programs. We try to stay with that kind of behaviorally stated aspect to this, is that there are services that are long-standing since the days child protection was developed in the late 60s, is daycare, for instance. Separates people. If we use it in an effective safety service way, separates child and parent at portions of the day or night, for that matter, if we're using maybe respite care instead of daycare, where we're worried that tensions are going to boil over. That might be the way that we would have said it before, using more precise language of, I can tell you what the threats are, I can tell you when they play out, I can tell you how intensely they operate, and this is what's needed. So daycare might be a type of separation service that we're using to coincide with some of these other sorts of services. We tend to think of the more people who can have their eyes and ears on this family, the better or greater confidence that we'll have. True, what we talk about is that we're looking at services that are aimed at, why would we want eyes and ears? Is it to control behavior or emotions that if somebody weren't stopping by a couple times a week, whether that's randomly or it's scheduled, that we think that that behavior would escalate, get out of control, and lead to severe consequences? Is it part of the lid? We're trying to get more and more precise about what we're asking people to do. As you look at these services, you can see that some of them, many of them, can be done by a neighbor, by a friend, by a paraprofessional. You don't have to have a fancy title. You don't have to be part of a nonprofit agency long-standing in the community in order to perform this service, or you could. When I was the director of child welfare services in Milwaukee, we had a lawsuit. I wasn't the director when the lawsuit was filed. I just want to say that. Not that. But as a result of that lawsuit, we reorganized and put in $20 million in that community of just safety services. Many more millions went into treatment services. So these types of categories that you see on bench card F or on the pages in the guide, that went out in RFPs. And it was very difficult to get service providers to understand, I don't want you to change anybody. I want you to put a lid on things. It's a very different kind of a service, and if you're hell-bent on, there's that French popping up, but if you're driven to change people, then respond to a different RFP, because we need these kinds of services in place. Now, you might say, well, I'm not living in a community where we can even put in $100,000 worth of these sorts of services. I have good news for you, is that 2 years later, Chapin Hall helped us do an evaluation of those safety services, and what we found is that more and more the cases where those safety plans that were put together were more effective, were sustainable longer over time, were those that were made up of not the purchase services, but those services that were part of the community, the family network. I mean, that makes sense, right? I mean, there's more of an investment, there's more of a willingness people to give until, you know, it's not needed any longer. So, but regardless of whether they're purchased or whether they're part of rolling up your sleeves and trying to figure out who in this family could play a role, we could be looking at putting together plans that might keep children in their own bed. But what I will say is that part of these actions and services that you see here have to do with separating people. And so whether that's just out of daycare, respite, temporarily going to scouts for the afternoon, or whether it's 100% out-of-home care. So we're really looking at a control mechanism here. We're going to get to the family service plan and what needs to change over time, or we'll be raising everybody under either in-home safety plans, or we talk very regularly about raising children in out-of-home care. That's another type of safety plan. So we're not trying to do that, and we're not trying to step away until parents can get back into the game and be the protective adults and caregivers that they need to be themselves, and thereby reducing the need for the safety plan. Where am I? I've been skipping around a lot. There's the math formula. It actually needs a plus sign on there, so I'm going to skip over it. Here's ASFA laying out, ASFA language, Adoption and Safe Families Act, laying out the concept of that the case plan has to control for safety. So there's that green part of this slide that is dealing with safety. And then the language within ASFA also talks about the need for us to be thinking about case planning efforts that aim towards changing those conditions that led to why the child needs to be out of the home. So we reach into the roots of this federal law that gives us the direction that there are two plates to be spun here. Is that concurrent, side by side, we've got to be looking for a lid to go on this frying pan that's out of control, and then a way to effectively reduce the heat so that we can eventually take the lid off of that pan. You would think that I was Martha Stewart with these cooking references, and I can assure you I use my microwave more often than I use my stove. I think I've already mentioned this now, is that within the safety plan, we got to be concerned about if we're seeing things that we just have to throw in there about how people need to, like, not give her the sleeping pills anymore, or stop using drugs, or start going to therapy. Is that this isn't about that, this is about how to get control over these threats. We've got some ideas here about ways to know whether what you're contemplating putting together, if you're the child welfare folks in the room, before you're ever even talking about it with the other legal parties, or whether these sorts of plans are being presented to you in some form and you're trying to decide whether they really are getting off the grid here and we're starting to talk about change instead. So we've got some bullet points up here on this slide about how do you know it really is a safety plan. And I'm going to reduce it to two. Is that what we're talking about being put into place in order to control for safety is immediately accessible. So if something is going to play out in the very near future, leading to severe consequences, I can't wait for a 4-week waiting list for some kind of intensive in-home program. I can't wait for grandma to return from a 3-week vacation that had been planning for months. It won't work. This has to be put into place now. I can't walk across the kitchen to a pantry that my new architect put in completely on the other side of the kitchen while I'm looking for a lid to that frying pan. I have to reach for it here to put it on. And then the other aspect of how you know the litmus test, the shorter litmus test than this, is it's a safety plan if it's immediately effective. And see, this is why I stress that this is not about drug treatment, this is not about anger management, this isn't about parenting classes, is that if I'm worried about somebody's immature, impulsive parenting so that they want to party at the drop of a hat, doesn't matter what the babysitter has arrived, I'm out the door when my friends arrive, the kids are sleeping, they'll be fine. And you say to me, good news, Terry, we don't have a waiting list in our county for parenting classes. We have an opening today. It starts at 4. I will drive you there. So there I am. You're driving me. You let me out of the car at 4 o'clock. I come back to your car at 6. You think I'm not impulsive anymore? That's what we mean by it needs to have an immediate effect. That parenting class may be very valuable. It may be something that I need, but it isn't going to keep my kids safe. So the issue is what's going to put in that lid, it has to fit. Can't be too small, can't even be too large, or stuff is going to be streaming out the sides anyway. So we've got one bullet point on this slide that speaks to never relying on parental promises. And we have this because it often is a thinking error that we see all over the place with everybody signing on to. You know, it's part of court orders, it's part of emergency orders, and it's part of safety plans that we see that are done by child welfare when the court isn't involved. So it doesn't seem to matter. It doesn't seem to be the likelihood of the thinking error doesn't seem to change. That is, the person who's the source of the threat can't promise then to control their behavior. We're talking about a threat meeting the threshold of something that's out of control, will play out soon, leading to severe consequences. So let's say it's that impulsive mom who wants to party at a drop of a hat and doesn't matter whether the babysitter's arrived. And so we write a safety plan and have her sign it, and we all sign it too, and it says, Mom will always have adequate child care for the child. Mom will never leave the children unsupervised. Or the threat has to do with somebody who's violent or really seriously impatient and smacks kids right across the face with a spatula when they're underfoot, when they're very stressed. Mom will never use physical discipline with the child. Or dad uses alcohol to the point where he forgets to supervise the kids, he doesn't feed them, he doesn't give proper shelter, clothing, whatever. And so, and we have all that information, and then we write a safety plan saying, Dad agrees not to use alcohol. We even help him throw out all the liquor bottles. You see safety plans that are written that way? Yes. I bet you do. Maybe in some pockets you've really worked to try not to do this, but we see us falling prey to this kind of thinking error an awful lot. It feels like it's just that necessary step to just tell people that they need to do this, and that if they sign this, and then we're mad when it fails. You know, we're mad at them. And we take them back and we try to escalate and we use it for case building. So we're looking at really trying to go about I spoke of a methodical way of approaching this. I have the answers to all the 6 questions. I've gone through a rigorous process to justify to you why certain threats of danger exist, and I can explain that. I can tell you why the kids are vulnerable to the threats, and I can tell you that there's a lack of any adult who's not the source of a threat who can be sufficiently protected of this. Wants to do the right thing, loves the kids to death, that's not the issue, cannot be protected. Okay? So in order to decide, is it in the home, out of the home, or somewhere in between, we walk through this process every single time, whether those kids right now were placed on an emergency basis. I'm thinking about them all in the same house. What would this be like? Or whether, like most of the cases, they never were placed on an emergency basis. Same exact process. How do the threats play out? Every day? Are they completely unpredictable? Is someone as likely to turn a table upside down and start a whole war in the kitchen because somebody looked at them the wrong way? Or are there triggers? This isn't a new assessment. This is, if I answered those 6 questions, I ought to be able to describe when the threats emerge, what happens, then what happens, what does this feel like to live in this household if you're 7 years old? Looking at that, then I'm going to look at the home environment itself, 2 prongs. Do we have people who are so violent? The culture of violence is such that every challenge is solved through violence. We're going to have people who won't participate in an in-home safety plan if that's the case. They'll be too frightened to be there. We also look at, even if that's not the issue, nobody's that violent. Nobody's violent at all, as a matter of fact. But we look at the chaos of this family. And while many of our families, most of our families, have an element of living crisis to crisis, having a certain amount of chaos that maybe we wouldn't be able to live through, we're pulling out those issues, those family situations where it's like a bus station. I can't keep track of who even lives here. You see, if I don't know the size of the frying pan, I can't get a lid for it. I'm walking through these ideas, trying to understand how the threats play out, whether there's any 2 of these issues about the home environment preclude the idea of thinking that an in-home safety plan would be sufficient to control. So violence I'm trying to rule out, so much violence that I won't find people who are willing to knock on the front door. And second of all, the level of chaos is so great that we can't even keep track of who's there. That would preclude an in-home safety plan. But assuming that it's not those sorts of situations, then I'm looking at, so those actions that we just looked at, the list, what would it take? How many times a day? Who could do it? Does everybody have to be a professional or a paraprofessional? Who do we have? This is the true meaning of demonstrating reasonable efforts. I already walked through what these categories are. We're looking at a 3-pronged test to any safety plan, whether it's out of home or in home. Is what you're putting together, it should feel logical. It should feel like a match. Like, now that you've explained to me what the threats are, how they play out, I get it, why you're asking that these sorts of things be put into place in order to control for this. And it's got to be sufficient. I know that sounds like it's got to be enough, 24 hours a day, 7 days a week. But what we really mean by sufficient is what it really means. Is it enough? And we don't want it to be too much, because this isn't about, if we need it 17 hours a day, why not just do 24 hours a day? It's easier. It's easier to say 24/7. Because the second issue here is that it has to be feasible. And so often we see safety plans, this is the second place where we go wrong, is that we ask grandma or somebody to move in, not really thinking about whether or not she's got another life, she's got bills to pay, she has somebody back at home, she has book clubs, she has church, and we're asking her to move in and to supervise all contact between the caregiver and, say, the 3 children in the home, 24 hours a day, 7 days a week. So grandma can't go out in the backyard and stand by the fence and have a conversation with people without dragging those 3 kids along if mom's in the house. Now, I got to tell you, if mom is that much of a beast, that that's what's needed, then let's not contemplate an in-home safety plan. Because this particularly is not feasible. Grandma needs to be able to take a shower. She needs to be able to run to Walgreens and fill her prescriptions without dragging those 3 kids along all the time. I mean, it's going to fall apart, and then we'll get mad at grandma because she can't make this work. And then finally, it has to be sustainable. If you're paying attention here, we got threats, vulnerable, and lack of protective capacity. You can see already that the family service plan is going to be not just about reducing threats, but it's going to be about increasing protective capacity. So this safety plan needs to be able to stay in place until we've got the parent able to do this more and more themselves, so that we can scale down the intensity of the safety plan until finally it's not needed at all. So if it's a in-home program that you love in your community that does the wraparound stuff and does all these things that are outlined in these actions, that's great. But if they say to you, but our program is only 8 weeks long, that's not so great. Unless you can say, in 8 weeks' time, these people are going to have sufficient protective capacity. Where am I? Oh, all right. So this gets into demonstration of reasonable efforts, doesn't it?
Yeah, sure.
I need to say goodbye to you.
You do.
Separation is so hard, isn't it?
Yes.
Yeah, I know.
Go quickly.
All right, I'm leaving.
Text me.
Bye.
Sound like
I will.
Text me.
Oh, thank you.
I know. I know, right? I'll tell you what. If you're someone in the legal community or a judge or a lawyer who walks out of this room and still has safety plans and family service plans confused, it's not you must have not been paying attention the last 15 minutes of your life. That was really dynamite. Thanks. Thanks. So, thank you, Terry, for illustrating so well what a safety plan is and what it isn't. And so now can you see how much more meaningful your reasonable efforts hearings and your reasonable efforts inquiries can be? Because part of determining reasonable efforts to prevent removal and reasonable efforts to reunify is answering the question, would an in-home safety plan be sufficient, feasible, and sustainable? And so it's that couple of slides ago, and it's in your bench card on reasonable efforts, on the questions to ask about the sustainability, assessing how do you assess sustainability, feasibility, and sufficiency for in-home safety plans. So where we are now is saying that beyond, I mean, in a lot of places there really isn't even a meaningful inquiry about reasonable efforts. It's a checkbox that gets checked, reasonable efforts are made, or, you know, and it really is designed and intended to be a useful tool for lawyers and a meaningful inquiry that the court engages in to determine whether or not, lots of things, but in this instance, reasonable efforts were made, let's say, for example, to reunify. The group of people, the discipline that I would say anecdotally loves the guide the most is parents' attorneys, because there is some rigor in here about what ought to go into these reasonable efforts determinations. And when you can start asking questions like, is there sufficient information, and do we have information under questions 3, 4, 5, and 6, and would an in-home safety plan be sufficient, feasible, sustainable, and how and when do the threats emerge, and answer those kinds of pointed questions, we get a better picture of what's actually going on in the family. And the debate there is then not about whether or not the mom gave the kids the sleeping medication. The debate is, well, what does that mean? And what, if anything, can we do to manage that threat? And what, if anything, can we do to enhance the protective capacities? And so case planning, family service planning, becomes about that instead of this boilerplate list of services that we assign because we don't know what else to do. The parenting classes, the substance abuse treatment, anger management, et cetera, that we see again and again and again. We will say it a little more provocatively at this point, but that reunification has less to do with compliance and more to do with has actual change occurred. And at this point in the presentation, that ought to make sense. So when we say early on that reunification is not based on compliance with the family service plan, people think, well, what's it based on? Because that's what we do. We make reunification decisions based on how many parenting classes did mom attend? Well, mom went to 9 out of 10 classes, so what? Did they make any difference? I had a case once where the judge said, the case had come in because it was a 13 or 14-year-old, and the mom had gotten into a physical altercation with her teenager, and we're working towards reunification, child had been removed, and the judge said, why are we sending this mother to parenting classes to learn how to change diapers? We're all sort of looking down, you know how you do as a lawyer, and you bury your head in your file like the answer's there, and no one even knew it. Well, the caseworker did, but the only parenting class that was available at the time was for infants and toddlers, because that one ran continuously. The parenting class on the troubled teens was like quarterly or something. And so, hey, the court order said parenting classes, we got to get her in. This is the one that's open, let's get her in. She went to, 10 out of 10 sessions. Who cares? So it's more about whether or not the change that we need to see in order to enhance, to speak in the language that we're talking about, reduce the threats and enhance the protective capacities. But I'm getting a little ahead of myself. So back to reasonable efforts. So all of this is part of reasonable efforts, but, and Terry covered this too, I love that bench card F, in terms of reasonable efforts to prevent the removal and reasonable efforts to reunify. How is it linked? Let me say it a different way. That if these kinds of services, both purchase services as well as services that the family can provide and that the community can provide, could create an in-home safety plan. And remember, I think we consider safety plans early on in the case, and then we don't even think about it 8, 9 months into the case, where there's been change that's occurred where a safety plan is going to be easier to develop, right? I mean, at least theoretically, because improvements have happened. So revisiting the issue of safety plan and considering as part of the reasonable efforts inquiry at the permanency hearing, have you considered an in-home safety plan? And that's all part of reasonable efforts. And if the answer is no, that the court ought to order that. And the good news with the second reasonable efforts finding, the reasonable efforts to achieve permanency, you can make a negative finding, and the 4E funding is discontinued unless and until there's a positive finding. I kind of hate to, at 4:30, start talking about 4E and funding, but it's a really important point. Let me repeat it a different way. The first reasonable efforts finding to prevent removal, if that's a negative finding, in other words, court says I'm finding that the agency failed to make reasonable efforts to prevent removal, the 4E funding is discontinued for the entire life of the case. But for the second reasonable efforts finding, its 4E funding is discontinued until there's a positive finding. I think it's really important because a lot of judges are reluctant to deny that reasonable efforts because of the impact. It is a big impact. If 4E funding for that child is discontinued, state's got to pay for all of the services, foster care, et cetera, out of their own pocket. It's not reimbursed by the feds. But it's an incentive because then the agency can go out and a good caseworker or a good agency attorney is going to ask that case to be set in 30, 60, 90 days, however long she thinks she needs in order to satisfy the court order that reasonable efforts are then occurring because, boom, the 4E funding kicks back in. So we're at the point now where we're saying if an in-home, let me back up. So just because the child is determined to be unsafe by virtue of threats present, child vulnerable to threats, and insufficient protective capacity, that does not necessarily mean that the child is removed. What it does mean is that we then consider what kind of safety plan, in-home versus out-of-home. Out-of-home being foster care, placement with the relative, etc. Out-of-home being out-of-home. Once we determine that an out-of-home safety plan is the only thing that's going to keep the child safe, two issues kick in. One is visitation, and two is conditions for return. So let's take them one at a time. So with regard to visitation, if you pull out bench card I cringe when I go into jurisdictions and there's a bright line rule that visits are always supervised unless, that's the default, that visits are supervised. The supervision or the lack of supervision of visitation is a safety decision. Why? Because in order to require that visits are supervised, you must be then saying that the child would be unsafe if they're not supervised. So we have if you look at the bench card, it talks about reasons why visits may or may not be supervised. First of all, are there threats present? And that some threats are more difficult to manage without supervision than others. For example, a child's intense fears, premeditated harm, violence, extreme negative percentage of the child, et cetera, et cetera. So ask yourself, what are the threats in order to make a determination about visitation? And then secondly, the volatility of the threat and how difficult it would be to manage without supervision. So if you think about it, the issue of whether visits are supervised or unsupervised is a safety decision and ought to be linked to specific evidence that demonstrate the volatility of the presence of the threat. I understand from our background prep conversations that how important I'm going to sound a little patronizing, but visitation is obviously important. The social science data indicate that it's one of, if not the most important predictor of reunification in terms of the timing of the reunification and the quality of the reunification. In other words, less likelihood for recurrent maltreatment. And I know that a lot of jurisdictions are doing a really good job with regard to the frequency of visitation. But I don't need to tell you that when visits are supervised, they tend to be less frequent, they tend to be shorter, and they tend to be not in a more natural kind of environment. So we really want to be careful that we've justified the reasons for the visits being supervised. So you've got some of the bullets up there. At the minimum, your visitation plan ought to include steps to maintain the attachment and develop protective capacity. So if we have more time, I'd give some illustration about how visitation can be linked to the enhancement of protective capacity. I know in some jurisdictions it's like heresy to talk about a foster parent supporting visitation or inviting the birth parent, the caregiver into the foster parent's home for the visit to occur there. So there's a whole piece that we could do about visitation with regard to safety, and it's a very important component to the family services plan. But again, it's linked to safety, and if nothing else, let's disabuse ourselves of this notion that visits have to be supervised just because that's the way that we do it and that's the way we think about it. The second issue, once we're talking about an out-of-home safety plan, so foster care, is conditions for return. I think it's one of my favorite aspects of the book. It's just so simple, and I wish I had had a concept like this when I was in practice. I just think I would have been so much more effective. And to tell you what condition for return is to say, how do we know when to reunify? Well, we establish specific conditions for return. And what a condition for return is a behavior and or a circumstance that must exist before an in-home safety plan will suffice. So I've said it in the vocabulary of the guide, but I think you get that what must exist in the home, either by way of a circumstance, a behavior, a perception, an attitude, etc. What must be present in the home before the child can be returned? So if you look at bench card J, and at the same time pull out Appendix D, which is on page 77 of the guide, which are examples of conditions for return, I'll walk you through this. So the day that I can tell you why an in-home safety plan will not work is the day that I can begin to draft the condition for return, because the condition for return is linked to the threat and to the gap in protective capacity. So the reason that I say this would have been so valuable for me when I was representing kids is that we get to these hearings and no one could really say what needed to be in place before the child ought to be returned. Remember, we were still under, without even realizing it, this compliance-based approach, like mom either had or hadn't complied with certain aspects of the case plan, but no one had really identified what the conditions for return ought to be and ought to look like. So we'd go to the hearing and mom was told, sorry, you haven't quite done enough, and what's enough? And you can see why people get frustrated with the system. Well, here you have identified conditions for return. Let's just look at some of the examples. So you say what the threat is. If you go to page 77, it gives the examples. So the threat, you've got to be able to remember it all starts there. And I had posed the question before the break, and Terry said during the break we don't have time to get comments on that, but I hope people thought about it when you looked at the 14 threats of danger that's on the last page of your guide, and ask yourself, have I seen these? Do these get communicated to the court? Like, wouldn't it be helpful to know what the Child Welfare Agency has established as the threats? What have they identified as the threats? Well, you take the threat, and here, the first one, no adult in the home is routinely performing basic and essential parenting duties and responsibilities. So the example of the threat, how's it play out? Mom possibly leaves her child while she goes out with her friends, 6-year-old's often left alone, et cetera, et cetera. So the conditions for return naturally flow from that. A responsible adult is in the home providing care and supervising the child. Plan for supervision by a suitable babysitter exists when the mom is away from the home. So it's overly simplified there, but you get the idea that the conditions for return are specific and they relate back directly to the threat. So when you're thinking about reunification, you've got to be clear about why the child was removed in the first place. And once you're clear about that, what the threat is and what the gap in the protective capacity is, you can then determine what the condition for return is, define it, and now you can see how we can talk about reunification in a more meaningful way and ask ourselves, do those same circumstances exist? Terry had glossed over this slide, so let's take a look at it with regard to safety plans. So the child's out of home. We've determined what the conditions for return ought to look like. I'm going to talk in a minute about the family service plan and components of the family service plan that's going to get us there. But what we want is this, right? The threat, which is controlled by the safety plan, so not completely eliminated, still present, but it's controlled by the safety plan, and then the safety plan is substituting for the compromised protective capacity. Boom, gets us to a safe child. That's just a reminder in terms of we're asking this inquiry. We're getting towards the chronologically speaking, the back end of the case when we're talking about reunification. And this is just to remind us that we're constantly asking about an in-home safety plan and whether or not it would be sufficient. And we're ongoingly gathering information in the case. And there are examples in the guide that talk about that, about the information gathering and how important it is to have it be present for that point in time. Let's see. Okay. So at the review hearing, the federal law, and this is pulled directly from ASFA, requires at both the permanency hearing as well as the 6-month hearing, and I understand, is it every county that has hearings every 3 months? Someone had sent me an email that there are hearings. I'm looking at the VIP table. It's okay. I just didn't want to get it wrong. So every 3 months, every 6 months. But ASFA requires at least annually, twice annually at the 6-month review and the annual permanency hearing that the court consider safety of the child. So it's right there in federal law. So now we have a richer understanding of what that means. and the identification of the threats, the continued necessity for and appropriateness of the placement, boom. Which is another way of saying, would an in-home safety plan now suffice? Extent of compliance with the case plan, but more importantly is bullet number 4, extent of the progress which has been made toward alleviating or mitigating the causes necessitating the placement of foster care. Said in safety guide speak, is extent of progress on the family services plan to reduce the threat and enhance the protective capacity. The same thing that bullet number 4 said. And then a likely date by which the child may be returned. When I was talking earlier about the raising the bar phenomenon, you also could say it's like a moving target for the parent who gets frustrated, and that imprecise, vague, unclear conditions for return leads to frustration. And parents are confused about what they must do or what they must accomplish, because you all know those cases where maybe they've even complied with the service plan and the child isn't returned. And as my old friend, the judge, would say, well, it's just gut instinct. I just felt like it wasn't going to work. Well, now we have some rigor, and we're saying that that there's still insufficient protective capacity, and here's why, and we have evidence to support that finding. So, the point of the treatment plan, or as you call it, the family services plan, is to increase the protective capacity and eliminate the threats. I've said that. And if you pull out bench card K, it gives us some insight into how we can increase the family service plan's likelihood for success. So distinct from the safety plan, which Terry said again and again, and I hope everyone is crystal clear on, a safety plan is not a treatment plan. A safety plan immediately controls for the threats. It's the lid on the frying pan. The family service plan is adjusting the heat. So we're not going to consider reunification. We're certainly not going to consider closing the case until that heat has been reduced. So, is the family services plan an effective and expedient strategy? And are we revising it over time to actually meet the needs of the family? Remember the mom of the 13-year-old going to parenting classes to learn how to change diapers. Now, when we're evaluating the family service plan, we've got to get away from looking at just compliance and whether or not mom is attending. We ask ourselves, do the services or are the contents of the family service plan, do they follow logically from the threats and the capacities? Can you see how if we haven't identified the specific threats and we're not clear about what we're working on with regard to the behavioral, cognitive, and emotional protective capacities, what are we doing? Does it target issues where the threats arise and where the protective capacities are compromised? And if you look at and I really encourage you, especially that appendix on the protective capacities, is to really look through it, where it talks about the reaction of the parent and the responsiveness of the parent, and what's been the parental reaction to the plan, the family services plan. So we're moving from a compliance approach to a behavior change approach. So as we're ongoingly gathering information to the 6 questions and we're assessing and cross-referencing those responses to the threats and to the protective capacities, we're determining whether or not we're seeing the kind of behavior change that we need to see. And again, I love that your goals are stated behaviorally, and with them stated that way and the criteria and the examples, we're a lot more clear about what it is that we're working towards in the family services plan. So one example, have the parents demonstrated the ability to put the child's needs above their own? So again, what's the change needed? The protective capacity enhancement. So the emotional protective capacity. So you ask these kinds of specific questions. Does the parent give time to the child rather than their own gratification? Do they spend money on the child's needs? Are meals, bedtimes appropriate? So can you see how this kind of specific information gets you an answer to that question about the parent's increased or improved ability to put the child's needs ahead of the parent's needs, that tells you a lot more about the family than whether or not she went to parenting classes. I'm feeling a little preachy. I appreciate that some people are nodding and smiling, but let me just pause and see if people have questions, comments. You want to take me on in some regard, because I don't know if it's because I'm near the end and trying to get through, but all of a sudden I felt preachy. Look at the slide. What I'm saying again is that it's this kind of information that we're assessing. And that's what I mean by a behavior change approach versus a compliance approach. And can you see how this would be more helpful? I used to get these court reports, and they would talk about, there was a supervised visit at the McDonald's. There's always a scene at the McDonald's. And mom blew up at the caseworker at the McDonald's. And you'd read it, and then it would get cut and pasted and show up in the next court hearing. And I'd think every time I'd read it, I don't really like her either. And I'm talking about the caseworker, not the mom. I find her patronizing. You know, I feel like I want to snap, you know, but she doesn't have my kid. So mom snapped at her at the McDonald's. Who cares? Who cares? Isn't this the kind of thing we want to know? And that's one example of the 30 or so bulleted list. So the more rigorous we are with asking these kinds of questions, which go to behavior change, the closer we are to knowing whether or not that child would be safe. Now I feel like I'm not only being preachy, but I insulted people because I had the example and I said I didn't like the kid. Yeah, dig me out here.
Before you finish, I actually think it's been superb, and we've been whispering among ourselves how to change funding to change behaviors, which we're a big believer in how to go further. Pennsylvania, from what we can tell, leads the nation in, and we're not proud of this, in teenagers in care.
Yeah.
And one of the things we've been whispering to each other is whether or not your concepts and your construct have any applicability, whether or not the, quote, danger would be the incorrigible kid, the kid that won't go to school, should danger be so expanded, whether that child's vulnerable even though he can beat his parents up or she can spit in her mom's face. So just before you finish, one of the things we want to attack is, and we're not sure what's going on. Should we just shut the door and say, school systems, this is your problem, delinquency, this is your problem, the dependency system doesn't care about these kids, or should we embrace them all and take them in? Does your concept work if you thought about teenagers?
Yeah. Excellent question. And while you were talking, I was looking down to look at the, you know, when people ask me a hypothetical, the first thing I do is pull out bench card B. I do. And I think, okay, well, let me see whether or not one of the threats applies. So before I talk about what threat may or may not apply, let me say this. Because I understand the incorrigible teens and the truancy problem. Truancy, or a teenager with behavioral problems, in and of itself does not really get us to whether or not the child is safe, right? Because we haven't, how do we know whether or not the child is safe? We do exactly what I did while the justice was asking the questions. We pull out bench card B, and we say, well, we need more information about the family. Remember the 6 questions. So, is a truant child unsafe? Well, I don't know. The reason I don't know is because I don't have sufficient information, because I don't have that. Remember the 6 questions. I don't have this whole universe of information. So the truancy or the poor behavior or the delinquent behavior in and of itself on the part of the adolescent doesn't tell me whether or not the child is safe. In and of itself, no. But is the child unsafe? Well, here you go. And this may or may not be present. A child shows serious emotional symptoms, require immediate help, and or lacks behavioral control, or exhibits self-destructive behavior, and parents, here's the key part, parents are unwilling or unable to arrange or provide care. So in some of the truant, delinquent youth, you might say that that threat is present, but maybe not. You'd need more facts, right? And then the second piece, looking at the protective capacity of the parent, the emotional, cognitive, behavioral protective capacity to manage that behavior, there's probably a gap there in the parent's protective capacity. So you might, based on sufficient information, reach the conclusion that that child is unsafe, and you might not. And you might have, I know it's not all that common, but some states that just put truancy in with the dependency system when it really isn't. And you got a 4E problem, you got all kinds of problems. So I'm sorry for the length of the answer, but it's a complicated answer because I don't know whether that child is safe, but what I do know is I'm going to go through the decision-making methodology with some rigor to answer that question. You with me? Okay. Let me just see if there's anything else. If you go to page, there's two more things that I want to draw your attention to. And one is page 43, which sums this up well. So we're evaluating progress using safety criteria. So safety-related questions at the review hearing would be this blue side. What do we know about progress of the case plan? What is the answer to the 6 questions? What's the status of the threats? Have any additional threats emerged? What's the status of the protective capacities? Are there differences of opinion among the parties? Have conditions for return been met? So these very, very simple. Can the in-home safety plan be revised to be less intrusive? If there's been little progress, is that because the family services plan doesn't have the right strategies, and or are the services and providers perhaps not appropriate to the task, or et cetera? So this is a very simple kind of way to walk through thinking about the review hearings and way to structure the review hearings. I also want you to take a look at the bench card. It's the second flow chart. So bench card E is the first one. Here it is, bench card H. I hate flow charts. I don't know. I had like this reaction to them like, oh, that doesn't make any sense. Like I see it and it's like it doesn't make sense. But this one is brilliant and does make sense. And if you just maybe spend some time tonight, because we don't have time now to do it, and really just look at it. The presentation is here with regard to the flow of how to analyze and think about the decision making. And when you get to the end of the case, so this is developing safety plan through terminating court jurisdiction. Terry's always fond of saying if you're closing the case at the same time you're returning the children, you've either kept them in foster care too long and you're returning them too late, or you're closing the case too early. In other words, there always should be a period where the children are returned home and there's an in-home safety plan, like the Koski case where it didn't happen. And there's an in-home safety plan managing that gap. So if you look in the book, the section on reunification is really short. Why? Because the inquiry about reunification is the same as the inquiry about removal. It's the same analysis. We're assessing for threats, we're assessing vulnerability, and we're assessing for protective capacity. So when we're closing the case, we expect to see the ongoing parental improvement over time. And threats of either, I probably shouldn't have put eliminated, we probably should change that. They don't necessarily need to be eliminated, although that's ideal and that's what we're going for, but sufficiently reduced so that the protective capacity on the part of the parents can now manage the threats. Remember what I said about our families of origin or our own families with our children, that from time to time threats have been present. And we also do this whole piece, I mean, you know, someone asked, they said, well, you really should have a chapter in there on bias. And we said that bias creeps in when we don't have criteria and we don't make safety decisions with rigor. And it's not just bias. When I say bias, I don't not mean cultural bias, racial bias, but also our bias towards who these families are. And this us and them mentality. Like that's something that happens over there and not over here. And the more you start thinking about safety decision making and really looking at the complex picture that the families present, seeing us in them and seeing them in us, that bias, eliminating that bias as well. But I could kick myself for bringing that up with 4 minutes left, but my point here is that the threats don't need to be completely gone in order to close the case, but we've got to be confident that there's protected capacity to manage the threats. And you could close the case even if you've got supports from family and others, and indeed social service agencies still in place. Again, several sources for the online version of the guide. I love the John Paul Stevens quote, "A decision must be born of deliberation and not happenstance, inattention, or neglect." And I hope that you have some sense from this presentation that we really can step up our game in terms of really understanding what we need to know about a family in order to make a safety decision, and what we need to include in these family services plans to improve the likelihood that reunification is going to occur in a timely manner. So thank you, and have a great summit.